Yes, I can still hear you.
Yes, Speaker, we schedule. And so things, statement were mentioned. Now the whip is telling us that we should vary order of business and take the bill, the legal education reform bill. There's no problem with that. However, I looked through this order paper today, and then I realized that the matter on the motion that was, filed by us, and Speaker, yesterday, are related to the same matter, and you said that you were waiting for some briefing on the gold for reserves motion that was filed. Speaker, you said you were waiting for some briefing and that the leadership would have to speak to Mr. Speaker. What I don't understand is that the motion is miraculously missing on the order paper. It doesn't find expression on the order paper. It doesn't find expression on the order paper. But that motion has featured in all previous order papers that have been printed.
Well, we have actually seen
and if it is the case that you want to do an order paper addendum, it is also revealing you want to do an order paper addendum because it comes to you as an afterthought. That is most unfortunate. Speaker, we will cooperate with you to do all the bills, but we don't understand why a matter that is so important to us, a matter okay, so in your considerations, don't leave out the golds for reserve motion. You have spoken to the legal reform bill. Yesterday we stayed longer than expected, longer than planned. Let me speak. You are standing. Let me speak. And yesterday we are just left with 10 clauses, and Speaker will be done. That is the commitment of our side of the house. Then our members are fully and actively participating in winnowing of the GIPC bill. Fully. That is how committed we are. Leader, that's how committed we are. So we are committed to prosecuting the GIPC bill. We are committed to making sure that consideration of the legal reform bill is done. You should also be committed to ensuring that our motion is moved and debated. Please. So give us a chronology. I'm not belaboring the point. Give us a roadmap. Today, is it the case that we are starting off?
How did they get off them?
With the legal reform bill? We have just about 10 clauses, I'm told. Then we'll be done. Then we'll go and take our motion. Then we'll go and take the GIPC bill our consideration. Establish that ab initio. No. Mr. Speaker, we are supposed, as leaders, supposed to help you guide the House. Let him itemize the critical issues, businesses to be prosecuted. Then we can move with him. We are ready to work. We are ready to stay overnight and work. But you cannot leave out our motion. Please.
Honorable Minority Chief Whip, so long as I am concerned, businesses to be conducted are by the order paper. It is only when they want to vary the order of business that they seek my leave to vary the order of business. So to ask that they should again itemize the business that we are going to conduct when we have the order paper, I don't know how that is going to happen.
You are a master tactician. And Speaker, we learn under your feet. There are a number of businesses. It is impossible for us to prosecute all the businesses listed today. So I just want a sense of what his priorities are going to be.
What you said is that he should itemize. The businesses are itemized. And then you have attested to the fact that we may not be able to carry all the businesses on the order paper for today. So as and when the need be that they will have to vary the order of business to jump, then my attention is drawn, leave is sought, and leave is granted for that business to be carried out. But to say that apart from the order paper, they should again itemize business to be conducted is what I am taken aback.
So I will always take a cue. Leader, let me just conclude. I will always take a cue from you. I'm simply saying that I have looked through the order paper and he has mentioned a particular business. Leader, you relax. We will do your business for you. Don't be in a hurry. We will do it for you. But you should also consider our motion. Speaker, we are the whips. He's my good friend. And when he starts winking his eyes, then I know he's not going to take my business. Speaker, we must take that motion.
I think when we go straight to the point,
yes,
we may even be able to do all the motions on the order paper for today. Yes.
Mr. Speaker, Honorable Jerry has been misleading the minority chief whip. Anytime that he's sitting by him, he's bad influence. I don't think that you can be saying that you are ready to do government business. You are ready to do our business for us.
As soon as Jerry comes in.
And at the same time, the time that is going to be used to do the business is the time that you are using the way you are using. So clearly, there's a game you are playing. Because if you hadn't started doing what you were doing, by now we would have finished the legal education reform bill. We would have finished. When we had the meeting, oh, we don't need the AG. The AG must not necessarily be in the chamber before we pass the bill or work on the bill. So, Mr. Speaker, let's proceed and start. As for your motion, like Speaker said, your motion is motion number 48. Motion number 48. You know, that's where your motion is. In fact, before your motion is my motion. I have a motion also advertised. Motion number 47. Even before that motion is another motion of mine. Motion number 46. So if we are going to go according to the chronology of things, I have to do my two motions before your motion can be moved. And my motion has been pending for more than 6-7 months as well. So I'm not the only person, you are not the only person whose motion has been pending for a long time. For my motion came before your motion. And my motion has been pending for a very long time. So, Mr. Speaker, I think that we should just go straight to business and try and clear the legal education bill.
Yes, Honorable.
Speaker, the majority leader has today called me a bad influence. And Speaker, that respectfully has been captured by the answer. And so I pray thee that
I withdraw that.
Again, not to litigate further. I'm not litigating. Yeah, let's agree. After, I'm just asking you, after the legal reform, go ahead.
In response to the minority chief whip, we will finish. My prayer is that we take item number 18 and finish the legal reform bill. We just have about 8 clauses to go. Then after that, Speaker, we will seek your special leave to take a couple of commemorative statements. Then the winnowing committee will return with a report. They are just done. They are done. They'll return with a report in respect of the GIPC bill. We'll take it, and then we'll zoom in into consideration and with that one.
Well, if it is a statement that I have not admitted, I don't think I'll preside over it. Legal Education Reform Bill 2025 at consideration stage, item numbered 1 at page 6, which is clause 73.
Mr. Speaker, 73 is just to take you back to delete. We missed that yesterday. Conduct of post-call law course and remedial courses have already been incorporated in some other clauses. Mr. Speaker, I move that we delete 73. I so move.
The proposed amendment is for the consideration of the House. Yes.
Mr. Speaker, the chairman must give us a satisfactory explanation, because by practice, when people sit the exams, some will fail. And when they fail, they need an opportunity for a receipt, and probably even a second receipt. Some may even go for the professional receipt. So he must assure us that he's not closing the door of that opportunity of persons who are not able to pass to have an opportunity to receive the exams in order to be able to call the bar. So he must read and convince this House that we are assured that persons who sit the exams at the first instance and fail will have an opportunity. So, Chairman, if you provide further clarity, we will support the deletion of the 73. I thank you, Mr. Speaker.
Yes.
Mr. Speaker, I appreciate the concern of Minister, and to assure him that, this has been variously covered in other aspects of the... Yesterday, we dealt extensively with receipt, procedure, and then the rest of that. I would, as I sit by him, I would refer him to the various clauses that have been covered. And as the rules permit, Mr. Speaker, flexibility in the consideration stage, if there's need to come back, we will do. Thank you so much.
I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. Clause 73 is ordered to stand part of the bill. Clause 73 is ordered to be deleted from the bill. Clause 82.
Request for information.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any amendment, I'll put a question. As many as are in favor, say aye. Aye. Those against, say no. The ayes have it. Clause 82 is ordered to stand part of the bill. Clause 83.
Regulations.
Chairman of the committee.
Mr. Speaker, clause 83, amendment proposed, subclause 1, line 1, after May, insert within 12 months after the coming into force of this act. Mr. Speaker, in line with our recent laws. Thank you.
The proposed amendment is for the consideration of the House. Yes.
Mr. Speaker, how can you use the permissive may and then indicate a timeline?
Exactly.
How are you going to do that? How are you going to say that the minister may, on the advice of the council by legislative instrument, make regulations for the effective and efficient implementation of this act within 12 months? So if he doesn't do it within the 12 months because he may not also do it within the 12 months, what's the implications for violating the 12 months timeline? So unless you want to delete it to say shall, if you make it mandatory and then you add a timeline, then it works.
Yes, Chairman of the committee.
Mr. Speaker, I think it's not fatal.
Very well. So change the may to shall. So the new rendition will be the minister shall within 12 months after the coming into force of this act on the advice of the council by legislative instruments, make regulations for the effective and efficient implementation of this act. I'll put a question. As many as are in favor of the proposed amendment, say aye. Aye. Those against, say no. The ayes have it. The proposed amendment is carried. Yes, 83. Chairman of the committee. Aye.
Speaker, I amendment proposed subclause 2 add the following new paragraph. Fees to be charged by the council in relation to an application, license, or any other service under this act. I so move.
It is for the consideration of the House, yes.
Mr. Speaker, if the chairman can clarify, if you are charging application fees, say so. If you are charging license fees, say so. When you go running around, fees to be charged by the council in relation. What is legal about the word in relation? Thank you, Mr. Speaker.
And Chairman, take into consideration to be charged. We move away from that. We draft in the presence.
Chairman, Mr. Speaker, I take note of the continuous tense as we ran away from it in drafting. So I would want to profile a new rendition that would say fees
to be charged.
Fees charged by the council.
Fees charged by the council in respect of application, license, or any other service. They take away in relation.
Yes, in relation. I don't see that.
In respect of.
Any further?
In place of, in relation.
Very well. I'll put a question. As many as are in favor of the proposed amendment, say aye. Aye. Those against, say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Chairman, amendment IV.
Mr. Speaker, we subclause 2 add the following new paragraph. The terms and conditions of service of staff of the council, including appointment, dismissal, remuneration, and retirement benefits. And I so move, Mr. Speaker.
It is for the consideration of the House. Honourable members, yes.
Mr. Speaker, we are doing legislation, clause 83, terms and conditions. And then you want to come and define appointment, dismissal, remuneration, retirement. If you say terms and conditions of employment, it should be enough for the elegance of it. But why are you listing? When you list and you leave out others, what do we do? Thank you, Chair.
Yes.
Mr. Speaker, I stand to be guided, but I'm trying to recall any act that we passed in which we said the terms and conditions of staff should be the subject of regulations to be brought to this House. I don't remember any act where we have said that the terms and conditions, if you state by regulation the terms and conditions, it means that any time that the terms and conditions of the workers is to be changed, they have to come back to this House with another regulation to change the terms and conditions. So we cannot have a situation where the conditions of service of workers will be determined by regulations to be brought to this House. Which workers' terms and conditions have been brought to this House for us to approve? It has never happened. So I don't know the basis for a proposal like that.
Article 124. Yes, Chairman of the committee.
Speaker.
No, Chairman.
Yeah, after that, very well. Let me take you first.
Speaker, thank you very much. The reason why they seem to be bringing the terms of conditions of staff here is because the school is being established, and under normal circumstances, this should have been contained in the statutes of the school. So if we can draft to make provision for these conditions to be catered for, because we have established the Ghana School of Law, which we are going to appoint some staff to manage. No, by this act too, we do establish by 78 of the new document, we have established the School of Law, the Ghana School of Law, as a directorate. So, but we should find ways and means to put this one we can take the conditions out, I agree. No, I agree we can take the conditions out, we have to figure out a way to capture it.
Honourable members, can we look at Article 1245, which I would want to read. The Parliamentary Service Board shall, with the prior approval of Parliament, make regulations by constitutional instrument prescribing the terms and conditions of service of the officers and other employees in the parliamentary service, and generally for the effective and efficient administration of the parliamentary service. So this is not novel. Yes.
Mr. Speaker, you cannot elevate the mechanism for the determination of a council established by an act of parliament to the status of a constitutional body, a coordinate branch of government. That's what you are seeking to do. Because you see, when the Constitution establishes the parliamentary service, you want to take it out? Good.
Yes, what is the position?
That they want to take it out. It should be ignored. So you are standing down the amendment.
Yes.
Mr. Speaker, may I humbly drop the amendment?
Very well. Amendment.
So moved.
You see, if you even look at the Securities and Intelligence Act that we have just passed, this provision is part of it. The Securities and Intelligence Act. It's also part of it. So I just use the constitutional provisions to demonstrate that if the Constitution can empower the Parliamentary Service Board to make regulation and come out with a condition of service of staff, then we may not be wrong also making law tasking the council to also make regulation on terms and conditions of service. This is not to equate it to a constitutional body. And there are other legislations that we have passed that this particular provision well featured. A good example is the Security and Intelligence Bill that has just been passed. It's also in it. But if you want to abandon it, I have no physician.
Speaker, I'm also getting convinced by the fact that the minister shall, on the advice of the council, so that same council that is advising the minister is going to determine the conditions of service of the council. This is where I tend to agree with leader that we can conveniently drop it.
This is a condition of service of staff of the council.
Staff of the council.
No, sit down, we help you. Mr. Speaker, with your indulgence, let me persuade the majority leader to abandon his objection, citing the reference to parliamentary service. If you take the kind of staff that will work for legal education, you are looking at their terms and conditions of employment. And it's important that provision is made for it in a regulation pursuant to Article 11 of the Constitution. So you shouldn't be insisting that because it's not a co-equal organ of state, conditions of service for public servants is conditions of service for public servants. What we want, and Mr. Speaker, I use, for instance, the parliamentary service. It is through these regulations that Parliament caters for the needs of the staff of the parliamentary service. So it means that the Legal Education Reform Bill is making room for persons employed to work within the general ambit of the General Legal Council. So if you would abandon it, but the chairman should abandon defining retirement, remuneration. Terms and conditions of employment is defined. It may include other variables that, for his purpose, he's not elaborating here. Thank you, Mr. Speaker.
Yes, Chairman of the committee.
Yeah. Mr. Speaker, whether we abandon this or not, it is implied under 83 that they can still perform that function anyway. And so I think it was just for purposes of emphasis. It is the minister shall, on the directive advice of the council by legislative instrument, make regulations for the effective and efficient implementation of the act. They can still come under this general clause. So,
yes,
Mr. Speaker, once you are admitting that it will still be by regulations, then we might as well just continue with what we are doing, because it is still going to be done by regulations. Speaker has tried to draw attention that there are precedents where we have used regulations. I just feel that to determine conditions of service via regulations means that at all times, if there's going to be a variation, you have to come back to Parliament for the variation. I thought that this would be quite a tedious, exercise. It might not even work in the favor of the workers. That each time that their conditions of service are going to be varied, then you'll have to go to Parliament, pass regulations before you can vary it. So I thought that there should be other ways of determining conditions of service instead of passing regulations. But I abandoned my objection, and we can pass it.
Mr. Speaker, on the basis of that, I want to go back to the student who cancelled his answer script, and when time was against him, he said cancellation, not cancelled. Mr. Speaker, I abandoned the fact that I want us to maintain IV.
Very well. I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. No, yes, the chairman's amendment. So I will now put a question. Now I'll have to put a question on entire 83 in the absence of any further amendment. Yes.
Mr. Speaker, I've seen in sub-clause 3 in the Gazette and on the website of the council. So that means on the website you want electronic, and then will the Gazette serve the other purposes? That's in 83, if I'm holding the correct bill. On the website of the council, there may be a rural person who has no access to a website. Are we assuming that the person will get it in the Gazette? Let me see.
So what is your proposal?
Beyond electronic, Mr. Speaker, unless I'm not, legal education bill 833.
So what is the proposed amendment? Very well. So I can put a question on the entire clause 83. As many as are in favor say aye. Those against say no. The ayes have it. Clause 83 is ordered to stand part of the bill. 84.
Interpretation.
Mr. Speaker, 84 amendment proposed add the following new definition. Director General means the Director General of the Legal Education appointed under Section 11. I so move.
It is for the consideration of the House. I'll put a question. As many as are in favor say aye. Yes.
Thank you, Mr. Speaker. Now, if you look at the interpretations, it says the council means the Council for Legal Education and Training, for which there's going to be a Director General. So is he the Director General, are we going to keep it a Director General of Legal Education only, or Director General of Legal Education and Training? So my proposal is to add "and training" instead of leaving it as the Director General of Legal Education and Training. Yes.
It is for the consideration of the House. Yes, Chairman of the Committee. Chairman of the Committee. What's your view about the proposed amendment?
The proposal, I think the chairman was not with us. So the proposal is that you move for an amendment of the interpretation clause to add Director General, and then for Director General to mean the Director General of Legal Education. And he is saying that throughout the bill, we've been talking about legal education and training. So you should add legal education and training.
Mr. Speaker, I think I'm in line with that.
Very well. So the new rendition will be Director General means the Director General of Legal Education and Training appointed under Section 11. Yes.
Mr. Speaker, for the avoidance of doubts, the last time we were at this stage, I recall that Honorable Kabiru had made this proposal and it was carried. So I don't know how come it's not reflecting, in the proposed amendments. I think it was carried right here in this hallowed chamber. So let the records.
It was a good observation that he brought. So you are in agreement with him. Are you in agreement with him, or you disagree with the proposal?
I want it to be put on record that this particular proposal had been proposed by Honorable Kabiru and carried here.
So if it is consequential,
exactly,
if it is consequential, and it is consequentially being carried, so the proposed amendment by Dr. Che is correct.
It's correct.
Is that not so?
But it has been done
before. And that is what we are putting the question on.
Very well.
Yes.
Mr. Speaker, first and foremost, we didn't get the sense that the proposed amendment proposed by Dr. Che was consequential to the amendment that was carried in the previous consideration of the bill. So that is the point that he wanted to establish, that we had proposed an amendment to the Director General for Legal Education by the addition of legal training, by the addition of education. So he is proposing that consequent to that amendment, we are having a consequential amendment to the interpretation by the addition of education. So that was the direction I thought you ought to have given us. But if it is carried as if it is a substantive amendment, that was the confusion we wanted to clarify with the intervention he made, Mr. Speaker.
I don't know where the problem is coming from. If there has been an amendment there is a further amendment which was not in consonance with the earlier one. And the honorable member is rightly drawing attention to it. Which position is correct and has been agreed upon? What else will I do apart from putting the question? Because the previous one was standing in your name. He is the one now drawing the attention that previously this was what happened. So I'll have to put a question on the amendment that he's proposing.
Mr. Speaker, no, I agree with, but I'm just saying that you have directed before this House that consequentially we should effect the amendment. So even if that direction was to be carried out, this proposed amendment would have been moot. That's the point we are just trying to, because you had directed that.
No.
You had directed that.
No. You see, this is a fresh amendment being proposed by the chairman of the committee. And he is making a further proposal to the chairman's proposed amendment. Yes.
Mr. Speaker, you know, I'm sure the honorable member for Wale wants Hansard to recognize him, that his royalties for participating in the consideration stage of this bill is that when the chairman moved the amendment, there was a further amendment by the honorable Che, but in the original thought of the member for Wale, Mr. Speaker, you can do this for him for the purpose of hand that this proposed amendment, even though moved by the chairman, had the support of the Honorable Che and Honorable Kabir, and then you put the question for the record.
Yes.
So he can go home and say
that is what exactly I want to do.
Bill, he was heard. Thank you.
As many as are in favor of the proposed amendment, further, yes.
Speaker, I know Honorable Harun Idrisu just made the statement on a lighter note. But Mr. Speaker, Hansard will record the printed language. So it is important that the matter is clarified. Mr. Speaker, the contention of the respected member of Wale is to the effect that he is the originator of the said amendment. Bona fides are bona fides, and it must be respected as such. So it's not a matter of that he wants Hansard to capture him as having merely participated. No, Mr. Speaker, we know the industry of Dr. Kabiru in this House. No, it's a matter of fact. The records will bear him out. We know his industry, a first-timer who participates in legislation. He argues well on matters. So, Mr. Speaker, it's not just for the sake of being recorded by Hansard. And I don't want, Mr. Speaker, what is factual is factual. Kabiru is a first-timer. We know what he does. We should give to Kabiru what belongs to him. Mr. Speaker, so he is the originator of the said amendment. We acknowledge that chairman of the committee is taking it up, but his contention is that same must be so recognized. Mr. Speaker, that is all about it. Mr. Speaker, that's all about it.
Would I ask Dr. Che to drop the amendment and let it be moved by Dr. Kabiru?
Mr. Speaker,
because it comes to the same thing.
Mr. Speaker, it was a joint. Mr. Speaker, it was a joint proposal. They worked together, Mr. Speaker. They worked together. Dr. Che and his colleague Kabiru. Mr. Speaker, in the minority caucus, we work as a team. We work as a team. It's a teamwork. We don't work in silos and we don't look for personal glories. We work as a team. So, Mr. Speaker,
minority leader, what do I do apart from putting the question?
Mr. Speaker, I am only putting across a point, but you can put the question.
Mr. Speaker, you can put the question. You can put the question. Say that they've worked together to achieve this, and we all know that in this legislation, even where the majority could not marshal its members, we've had these two as constant. Mr. Speaker, there's always a way to get the majority chief whip on his feet. Mr. Speaker, I mean, if he's not comfortable with it, same is, he should let it slide. He should let very well. You should let it slide. You are my classmate. Very well, let it slide. Oh, what do you mean? Let it slide. Let it slide. Majority leader, if you want to be on your feet, you have other serious matters. Mr. Speaker, the majority leader knows that he has other serious matters that will require cooperation. I say let it slide. That's okay. Let it slide. If he wants to pursue it, he should pursue it at his own peril.
Yes.
Mr. Speaker, this one won't slide. It won't slide.
Mr. Speaker, put the question.
Those in favor of the proposed amendment say aye. Those against say no. The ayes have it. The proposed amendment by the chairman of the committee, further amended by Honorable Dr. Che, based on consequential amendment proposed by Dr. Kabiru, is ordered to stand part of the bill. Yes. Chairman, VI.
Mr. Speaker, VI add the following new definition. General Legal Counsel means a counsel established under Section 1 of the Legal Profession Act, 1960, Act 32. I so move, Mr. Speaker.
It is for the consideration of the House. Any further amendment? In the absence of any further amendment, the question is those in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Chairman of the committee, VII.
Mr. Speaker, the third amendment under clause 84 add the following new definition. Law program means a Bachelor of Laws degree and law practice training. I so move.
Honourable members, it is for your consideration. Any further amendment? Yes.
Or any other, Speaker, we need to further expand it to include or any other accredited program. Because, Speaker, the intention is that some of the faculties or law schools may introduce diploma programs in the near future. So, or any other accredited program in defining a law program. Don't limit it to LLB and the professional program or any other accredited program. I think that should be included in the definition.
What do you envisage to be any other accredited program?
Under this legislation, we have established the Ghana School of Law to offer, in fact, post-law programs. It is not an LLB program, and it is not the licensure, the professional training program that will lead to the licensure. It's a post-call, but it's accredited. So, good. Yes.
Mr. Speaker, I want to propose a further amendment by the deletion of means and substituting with includes. Law program includes a Bachelor of Laws degree and law practice training.
Majority Leader.
Mr. Speaker, we are defining a term consistently used in the bill. And consistently, two law programs have been in contemplation. The first is the degree which qualifies you to embark on the second, which ends up with a practicing law training program. So that is what consistently we have intended to express in the bill. So when we are defining, it is that which we are defining, not in future what might happen, not what might happen in future. So because we are defining an expression used in the bill, and at all times in considering this bill, I've only heard Bachelor of Laws degree, and then, law training, law practice training. So that's we should limit it to that. No, there's no mention of a diploma anywhere. There are provisions about post-call program, but even the post-call program is not a diploma. It's just to prepare you to write the courses that they think you should write in order to be called to the bar or to be permitted to practice within the jurisdiction, because you've already been called to the bar in some other jurisdiction. So let's limit it to the two terms, which is Bachelor of Laws degree and then also the law practice training.
Speaker, for the first time, I will disagree with my boss. Speaker, yesterday we adopted new clauses for the establishment of the Ghana School of Law. And Speaker, as part of the functions of the Ghana School of Law, we are saying that the Ghana School of Law shall A, administer the post-call law course. Yes. Yeah, the post-call law course. And that's a law program. It is. It's a law program. And we have established who and who will be eligible to participate in the post-call law program, or law course, I should say. So once we are defining what constitutes a law program, we should advert our minds to these special areas of training, to include them. We may not be specifically mentioning them, but once you introduce includes, these are accredited. These are courses that are accredited, and they'll be run by one of the institutions that we are establishing under this act. So if my boss if leader can avert his mind to that, then it will serve the purpose. They wouldn't have to specifically define. Yes, that's why I'm saying that. I think he got up about the inclusion just to say that it should be exclusively referred to the LLB and then the professional training. But I'm just trying to draw his attention to the fact that once we are establishing the Ghana School of Law to run courses like this, I am even of the view that this house.
All the issues that you are raising,
yes,
the answer is in clause 74 of the new bill. And if I may read, qualification for enrollment. A person qualifies to be enrolled on the roll of lawyers if the person A obtained a Bachelor of Laws degrees from a university accredited by the council. B, hold a law practice training certificate. And C, passes the National Bar examination. 2, despite subsection 1, the council may recommend the enrollment of a person who qualifies to practice law in a country with a system of law analogous to that of Ghana, which has a reciprocal arrangement with Ghana. B, has successfully completed the post-call law course conducted by the Ghana School of Law and passes the bar examination. So that one is something that the council may recommend. But for the purposes of this act, if you are talking about a law program, you are talking about the Bachelor of Laws and the professional practice training. That one may come by way of a recommendation by the council in line with 74(2).
Speaker, my difficulty is that how do you categorize what is to be done by the Ghana School of Law? How is that categorized? Is that an apprenticeship? Because the post-call, they write exams. It's not just tuition. They actually go through, it used to be 6 months, now they do a 1-year tuition program, well structured with a curriculum. And they write examination. When you pass the post-call, then you are recommended. Now, if you limit the definition of a law program to these two, tomorrow I can challenge the fact that what the Ghana School of Law is doing is not a law program. So it cannot constitute a basis for the council to make any recommendations. So you support me. Okay, then so yes. All I'm saying is that if you look at, okay.
I think that the problem is being more serious than we are debating. Because all this while, I've been scanning through the bill to see where law program is used. I don't know if the chairman has been able to identify any specific mention, any clause that says law program. Because it is consistently law degree program or the law practice training. There is no mention of law program that you are trying to define. Where? Which clause?
Now, go to clause 3B.
3B?
Yes. Clause 3B.
3B. B. I'm holding the old copy. In collaboration with the Ghana Tertiary Education Commission, set the standards for the accreditation of universities. Which other clause?
There is a proposed amendment to it to delete university and then put in place law program.
Oh, okay. So that okay. That's why you are defining it, because I'm holding the old copy.
Oh, because if Speaker,
yes, you have the floor.
Speaker, if you look at 52 grading standards, a university that runs a law program. After that, if you come to 3, a university that runs a law program, there are a lot of them.
Yes, it's been used several.
52, 53, 54, 55, 56, a lot of them, leader. So we may have to really define it.
Yes.
Mr. Speaker, rightly so. So all the subsequent ones that we find in other clauses are all premised from the amendment that we made under 3B. Under 3B. Yeah.
So clearly, the program is Bachelor of Laws and then the law practice training. However, the 74(2) is giving room to the council where such recognition is made. It is then that the post-call will kick in. So far as this legislation is concerned, it's talking about the Bachelor of Laws and the professional practice training. Yes, let me hear you, Honorable Fifth.
And Mr. Speaker, looking at even the post-call courses, which my Honorable Chief Whip is trying to say we define or add to the definition, those courses are courses that are found either in the LLB or the law practice. So it is part of the legal education courses. So it falls within the LLB or that of the practice one.
Yes.
Mr. Speaker, the programs that we envisage the Ghana School of Law has established to run include the post-call. The post-call has its special curriculum with examinations. Yes, the courses, they are running those courses because you are supposedly qualified in a jurisdiction outside, that is with a legal system that is analogous to the legal system, but you have been undertaking those courses, so you can fail. That is a law program. No, they are not. They are not. So I'm saying that once we seek to define, we should enlarge it enough to accommodate those general courses.
Honorable Chief Whip.
Speaker, if I may land.
Yes.
Because you are saying that for the purposes of this act.
Yes.
And for the purposes of this act is the one establishing what the Ghana School of Law should do and giving it functions. So we must be careful how we limit, how we define courses. Otherwise, tomorrow we'll run into problems. So the includes gives latitude. Once you say includes, it gives latitude.
Honorable AG, what do you want to be the definition of a law program? Should a law program in the context of this bill be defined to include the post-call?
Yes, Mr. Speaker. The reason is simply that if you don't define it to include the post-call, then it means that the post-call will fall outside the statutory framework of this bill. So I think the Chief Whip is right. And as he explained, the post-call law course is meant for those who are qualified in foreign jurisdictions and want to become lawyers in Ghana. So it's a program, and it is one where they study the basic foundational laws of Ghana. So constitutional law, our land law, family law, customary law, as well as our legal systems.
Post-call, will they also write the bar exams?
They will write the bar exam after they have, passed the post-call. When they have taken the post-call program and passed, then they qualify to write our national bar exam. They are not automatically, admitted to the bar. Yes.
They will write the exam.
Well, I'm not getting it like that. Flowing from 74, AG. 74.2 is saying that despite subsection 1, the council may recommend the enrollment of person who qualifies to practice law in a country with a system of law analogous to that of Ghana, which has a reciprocal arrangement with Ghana. Then 2, has successfully completed the post-call law course conducted by the Ghana School of Law and passed the national bar exams. So what should be the correct rendition for the definition of a law program?
Mr. Speaker, we substitute means with includes.
Then I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Yes, Chairman, VIII.
Speaker, VIII add the following new definition. Law dean means a person responsible for a law program of a university. I so move, Mr. Speaker.
It is for the consideration of the House. Any further amendment? I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Chairman, IX.
Speaker, IX, amendment proposed. Insert the following new definition. After the definition of tribunal, university means a tertiary education institution. I so move, Mr. Speaker.
It is for the consideration of the House. Honourable members, any further proposal? I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Now I'll put a question on the entire clause 84. As many as are in favor say aye. Those against say no. The ayes have it. Clause 84 is ordered to stand part of the bill. Clause 85.
Revocation.
No advertised amendments.
It is for the consideration of the House. Any proposed amendment to clause 85? In the absence of any proposed amendment, I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. Clause 85 is ordered to stand part of the bill. Clause 86.
Consequential amendments.
Speaker, clause 86, amendment proposed. Delete and insert the following as advertised on page 8. I so move, Mr. Speaker.
It is for the consideration of the House. Honourable members, any further amendment? I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. The proposed amendment to clause 86 is ordered to stand part of the bill. Now to clause 86. Those in favor say aye. Those against say no. Clause 86 is ordered to stand part of the bill. Clause 87.
Savings.
Chairman of the committee.
Speaker, no advertised amendment.
It is for the consideration of the House. In the absence of any further amendment, I will put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 87 is ordered to stand part of the bill. Clause 88.
Transitional provision.
Chairman of the committee.
Speaker, clause 88, amendment proposed. Delete and insert the following as captured on page 8 and 9. I so move, Mr. Speaker.
It is for the consideration of the House. Any further amendment? In the absence of any further amendment, I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. Clause 88. The proposed amendment is ordered to stand part of the bill. Chairman, XII.
Speaker, XII under clause 88, amendment proposed add the following new subclause. Speaker, as captured on page 9. I so move.
It is for the consideration of the House. Honourable members, any further amendment? I'll put a question. As many as are in favor of the proposed amendment say aye. Those against say no. Yes.
Speaker, just
yes.
The XII, just for our own elucidation, if you look at the last line, okay, if you read it, it says, a student enrolled in a professional legal training program before coming into force of this act shall continue under the existing regime. Mr. Speaker, just for your guidance, so which one would be the existing regime? The new law that would have been made, or the one that would have been repealed? Just for clarity, Mr. Speaker.
Well, I do not see any ambiguity by chairman of the committee. This is talking about a transitional provision. So those in the law school now, the system that applies for them to become a lawyer will continue to apply to them. Probably the understanding is that they will not be writing the bar exams. But the students that are going to be employed under this act, they will be writing the bar exams. That's why the savings and then the provision is saying that whatever is the existing regime will be applicable to the existing students.
Speaker, rightly so, because the contemplation of this bill, it's for those who are currently not at the present law school. And so for LLB students who are, yes. Yeah, because the law is not passed yet. So there's an existing law school. Yes. It's okay.
You see, honourable members, the issue is whether the law that you are passing now will take retrospective effect to affect the continuing students. So the answer is no. Therefore, those students will be under the existing program because this law is not in effect yet.
Speaker, I think that we can make it clearer because you see, once this old law, once this is passed, that old law will not be called an existing regime. The old law, we cannot refer to the old law as an existing regime. Existing regime will be the new law. Speaker, we just have to make sure that it is clear enough because if we are even disagreeing about this here, you can imagine the confusion that will be out there. So let's just make it clearer. Existing regime. By the time this law will be enforced. Yeah, if you say the law that was enforced before the coming into force of this the act, that's clearer. But if we say the existing regime, which existing regime would that be? Because if the person drafting this was thinking about what is going to be a repeat law, you understand? And example, I'm not a lawyer, so some don't be.
Mr. Speaker.
Yes.
The essence of this house is to deal with some reforms within the existing regime. And as soon as assent is given to this law, it becomes effective. It becomes effective. So the transitional provisions must be in respect of arrangements that to protect the interests of the current students in the system and the future or the prospective students. Please. So the laws, the standard of legislating in this house is that if you want to save provisions from an existing enactment and make it effective in the new law, we do so. So they become applicable as part of the new law. Otherwise, the new regime will be the effect of this law. And Mr. Speaker, when we speak of the law school, we are no longer speaking of LLB holders. We are saying that the law schools will run LLB program with proper curriculum defined under this act or program under this act, and then the professional training stage. So are we going to say that, for instance, those who are in level 100 now, in my alma mater, Faculty of Law, University of Ghana Law School, though for the next 6 years or for the next 5 years, there will be a certain regime that will govern their training and a certain regime that will govern the training of those who will be coming immediately after them. So there will be a huge confusion. So the transitional provision, we must avert our mind to the fact that where there are provisions in the existing law that we think should be applicable to situations going forward, we save those to make them part of the new law. That's all we do. So it cannot be that we are saying that an existing regime, it should be the law enforced. It should be the law enforced. So the language the drafters it's a standard provision that we adopt in all the legislation. So they should look at how we couch it in other provisions in terms of the transitional, in terms of the transition. But Speaker, finally, this law, our intention is to make it effective immediately, so that the law schools will take immediate steps to put their house in order in compliance with this law in training our students. There will be a huge disappointment if they hear that the law we have enacted will be applicable to those who are in SS and are yet to enter. Exactly. Oh, you are saying no, now you are waking up to the reality. So that is not the intent of this house. It should be effective immediately.
Well, so let's look at it this way.
So
students in professional part 1 who have written their exam, the professional part 1 exam, they are now in professional part 2, writing to be called to the bar. Are we going to stop them to say that they must also write the bar exams before they are called to the bar?
Speaker, no. That is why the provision in the existing law that will make that possible, we save those provisions.
Yes.
And make
So
it
if you are saying that this law, when passed, it must take immediate effect.
Yes.
That's where I have.
Speaker, it will take immediate effect. The effect of transitional provision is to save clauses and sections of existing law and make it.
Yes.
Exactly.
Yes, right, that has been accrued.
Yes.
Yes, because for those students, their right has already accrued.
Exactly.
So all that the provision is seeking to do is to exempt them from the application of this law.
Exactly. Exactly. But the LLB holders, that will be prospective, Mr. Speaker.
Yes.
But those who are at the LLB level now are expecting that they'll write the final bar exam. You know, and they will not be writing, and then they will not be subjected to a certain entrance exam. And as a result of which they are sieved.
Yeah, as for that one, I think we are on the same page.
Okay.
Because some people have written the entrance exam already.
Yes.
And they are already at the law school.
I agree with you.
You understand? So those are the people whose rights have accrued.
Yes.
So in order not to subject them to the new law, and in order for the new law not to take retrospective effect, there is the need for this particular provision to serve their rights.
Speaker, but the definition of the law school under this law is no longer co-terminus to the Ghana School of Law or Ghana School of Law. It enlarges to the law schools as we know it, the faculties as we know it.
Mr. Speaker.
Yes, leader, maybe let me hear them before I come to you. Yeah, Honorable, you know.
Thank you, Mr. Speaker. Mr. Speaker, I think what my colleague is saying is the use of the word existing law instead of applicable at the time, which you could see that in the earlier provision, it made use of, if I may read, Mr. Speaker, a person, 93, a person who before coming into force of this act is enrolled at the Ghana School of Law, concluding, it says that the law calls under the applicable enactment and curriculum in force at the time of enrollment. That is so clear. But this one, it says existing law, and the colleague is saying that if we pass this law, this...
It didn't say existing law.
Existing regime.
Yes.
And I'm saying that if we pass this law would now become the existing regime. So
you see, before this law is bringing out a different arrangement altogether. You understand? Before these arrangements will come into place, there is an existing regime where a person can become a lawyer. There is a regime in existence before this law. So they are saying that the students who are there before the coming into force of this law They must go by the existing regime. Yes, Honorable Patrick Yauboma.
Mr. Speaker, I think we can look at it this way, from this rendition. A student enrolled in a professional legal training program before the coming into force of this act shall continue prior to the coming into force of this law. But that's all.
So continue how? That will be the lacuna. Let me hear Baba Jaman.
Yes, Mr. Speaker, yes. I also, if you ask a simple question that if this law is passed today, does it take immediate effect? If yes, is it what becomes the existing regime? That will be the question that we need to answer. So if the new law is going to be the existing regime, then we need to look at the rendition here. Because they are saying that a student enrolled in a professional legal training program before the coming into force of the act shall continue under the existing regime. Somebody will interpret that to mean that the law in force. So it can be either we say, if you say existing regime or the act shall continue under the then existing regime or the applicable regime at the point of enrollment. So we need to clarify that, because otherwise I may interpret it that the existing regime is the act that is in force.
Maybe we have to qualify it by saying the existing regime before the coming into force of this law.
Exactly.
Yes. Let me hear majority leader, then the AG and the chairman will finish it up.
Mr. Speaker.
Yes.
The amendment proposed that I see advertised says 88, that's transitional provisions, clause 88, subclause 1. A person who, before the coming into force of this act, is enrolled Have we taken XI? I didn't. Have we taken XII? We've taken XII.
XII is under reference.
But I think the chairman has an issue with XI. No, the chairman has an issue with XI. He has an issue with XI.
Chairman, I put a question on the XI. We are now talking about XII, which is the amendment under reference. Yes, Honorable John Dako.
Speaker, leader, if you may, maybe if I can explain what has happened to you.
Just propose.
So,
Honorable Chairman of the committee, what is the situation?
Speaker, we're on XII now, but I will crave your indulgence. Annex II, we're looking at the word existing regime. Mr. Speaker, I want us to tweak the amendment a little bit to read a student enrolled in a professional legal training program before the coming into force of this act shall continue under the regime prior to the coming into force of this act. We delete the existing. We delete existing.
Honourable members, I'll put a question.
Yeah. Oh, it's yours.
Those in favor say aye. Aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Yeah. Yes, Chairman of the committee.
Mr. Speaker, while we had traversed XI, I crave your indulgence to take us back to XI2.
Please do.
Mr. Speaker, let me start with XI1. A person who, before the coming into force of this act, is enrolled at the Ghana School of Law and is undertaking the professional law course shall complete the professional law course under the applicable enactment and curriculum in force at the time of enrollment. These were all in agreement. But 2 now says, a person who completes a professional law course under subsection 1 is eligible to apply to sit a national bar exam. That cannot be. Whoever finds himself in Makola now, whether professional 1 or 2, must go with the old curriculum. You cannot be asked to go back and write the law, the national bar examination. So I propose that we delete 2. The person has accrued rights.
Yes, it's a good proposal.
Yes.
Yes. Honourable Patrick Yaboma.
I agree.
Yeah.
I don't ask.
Okay, that's fine.
Mr. Speaker, government can also decide to give this new act some space to take effect. Government can decide that, look, this act will take place or will take effect in next year or 2 years to take care of what Honorable Shaibu's apprehensions are. Because you see, Mr. Speaker, if we allow this provision to be deleted, what will happen to those who would have taken the bar exams, the part 1 exams under 1? Those rights would have been accrued, number 1. Number 2, you are saying that those under subclause 2 will not be eligible to apply to sit in the ensuing exams. That cannot be, because you'll be denying them. They would have started the program already. The program is not only for part 1 and part 2. It's a total program. Once you enroll, you have a legitimate expectation to sit for that exams. Attorney General, once you are enrolled, you have that legitimate expectation to sit for the exams. So it cannot be that I've sat in part 1 and I cannot be given that right to sit the national bar exam when I get to part 2 because there's a new law in force. You'll be denying me. You have to look at that carefully.
Honorable Baba Jamal.
You see, if you seek to delete that completely, it means that if somebody who studied under the old regime and happens to fail, you are closing the door for him to progress under the new regime. So if the person writes the old regime and fails, and thinks that he's competent enough to go under the new act, he should be given the opportunity to do so. So, if the person studies under the old law, he can't be eligible
to write the bar exams under the new act. So I think that we shouldn't delete that too completely. We should allow it there so that when a person fails the first one, he can decide to go under the second law and then write it under the second law. I think we should allow it.
Yes, but if you complete the professional law course, like what is here, a person who completes the professional law course under Section 1, how on earth will you complete a professional law course and again be eligible under the existing regime to write the bar exams? Because once you complete the professional law course, upon passing, you will be called to the bar.
No, Mr. Speaker. People complete the training all right and fail.
No, but if you fail, that doesn't mean you have completed.
Yes, that's it. You see, you complete.
No.
Mr.
It's
Speaker.
not. It's completion here does not mean passing through. You have satisfied the requirement.
Mr. Speaker,
Then you have
the interpretation of completing, because completing means that you would have completed and passed and called to the bar.
So let me ask you a question. A student of senior high school who did not write the SS examination, can he claim to have completed senior high school?
Oh, so Mr. Speaker, if he, at the end of the 3 years, they are going to write the exam and then he fell sick and he's not able to go and write.
So you have completed?
He would have finished the course.
You didn't satisfy the requirement.
No. Anyway,
yes.
My point, Mr. Speaker, my point is that we should fine-tune that too, to allow people who might have failed under the old regime to have the opportunity to write in the next regime. That's my point. Otherwise, you close the door completely to those who might have failed and could not go here.
Yes.
I think I'm of the view espoused by the Speaker that if you have completed, you are entitled to be called to the bar. But I also understand what we are trying to cure. So maybe some rendition that addresses that, which is basically to say that if you have gone through the professional law course and you are not successful in the examination, room should be created for you to be eligible to write the National Bar exam. Given that you have already gone through the law programs, and the new regime makes provision for those who have gone through the law programs to write the National Bar examination. So if you go through the law program also under the old regime, but you fail to pass the examination, you should be among those eligible to also write the bar examination. We as a parliament can confer that privilege. We can confer that privilege on those that have gone through the law program but have failed at the end of the program. But then, because they've gone through the program, they can prepare and write the National Bar examination. I think that is the proposal. That's what.
Is that before AG comes in, Speaker, the current arrangement is that you join, for instance, University of Ghana School of Law for your LLB. You progress to the professional stage. You go through the training, write all the set exams, and you are prepared for the National Bar exams. Now, in respect of what leader is saying, if you are a product of Makola, it means you must apply to Makola for them to submit to you or present you to the National Bar Council for the exams when this comes into effect. So there's no lacuna at all. Wherever you train, you have to go back to your school to apply to be presented to write the national bar exams.
AG, let's hear from you finally on this issue.
Mr. Speaker, I think the confusion arises from conflating the national bar, the professional law course with the law practice course. Because the law practice course under the new regime is the stepping stone to writing the national bar exam. And remember that we provided that you must be issued with a certificate from the accredited law school where you did your law practice course, right? So if somebody currently doing the professional law course at after the enactment of the law is doing the professional law course, and as you said, the person merely passed through but did not qualify to write the bar exam, and this regime comes into effect, then that means that they will have to register and write the law practice course and qualify, because that is a stepping stone to the bar examination. They cannot be allowed automatically to write just because they have passed through. Yeah, but Mr. Speaker, the rendition is not it doesn't capture the spirit of the policy. So we need yes.
Patrick Buama.
Yeah, to add to what the AG said, Mr. Speaker, the AG is mandated to come with some regulations to give effect to some of these issues that we are talking about. And he agrees with me that those issues that we are not finding solutions to, especially with the law practice course and the bar exams, he is supposed to come with some regulations to give effect to some of these challenges that we are seeing. And that resolves the problem, Mr. Speaker. And he agrees with that. AG, your regulations will resolve.
You see, honourable members, what is the existing regime? At the law school, if you fail one paper, you will do a receipt. But if you fail 2 papers, then you must repeat the year. That's the arrangement in place now. So you can say that based on the arrangement that is put in place, you cannot say you have completed the law school without passing the exam. You are either resitting or you are repeating the entire year. So the understanding of completion of the program here means that you are successful. That is what it means. So that's why I'm asking a question. How do you complete this program, yet you have a problem being called to the bar? I am saying so because of the arrangement that is being put in place. You won't complete and be called to the bar until you satisfy the requirement. So you are either repeating the year or you are writing arrears.
But Speaker, I'm sure after the coming into effect of this law, the second-year students,
yes,
who will fail a paper or 2,
yes,
will not be able to write or recite the paper.
Well, they should be able to.
And under what regime?
For instance, the transitional provision that we are putting in place says that those who are already in the law school now, they must go through the existing regime. So if the existing regime has a provision for you repeating or reciting one paper, the arrangement must go with you. Yes, it's possible. It is possible. So, honourable members, do we delete the provision or we allow it to stay? In the meantime, to continue the argument, permit me to acknowledge the presence of some revered guests in our midst. First on the list is Reverend Father Andrews Campbell, head of Weja Leprosarium, and 5 cured lepers and staff of the Weja Leprosarium are in our midst. We also have a YIM MA Junior High School led by Francis Walanyo Anku, head teacher. They are from Equiapim South, they numbered 66. Then we have Shio Success College, led by Francis K.M. Alowodo. He's the director. They are from Ewutu Senya East, they numbered 75. Then we have Jukwa Senior High Technical School, led by Francis Atta, a teacher. They are from Himan Lower Dentra. They numbered 64. Then we have Father Andrews, we have announced him already. Then we also have Local Council of Churches, Papasi area, led by Reverend John Kosa York. General Secretary, they are from Ewutu Senya West, they numbered 18. Honourable members, on your behalf, I welcome all of them to Parliament of Ghana and urge them to have a very fruitful visit. Yes.
Speaker, this is just a special prayer, just to, apart from acknowledging Father Campbell. Speaker, tomorrow he's going to be 80 years. And he's an Irish missionary born. He's been in Ghana for about 50 years. He's the head of the Lepers Aid Committee. He's the head of the Weja Leprosarium. He's from my constituency. And he served well. So, Speaker, I thought that I should take the opportunity to wish him a happy birthday. And yes. Wherever he votes is not the matter. I love him because he's Father Campbell and he served well, Speaker.
Yes.
Thank you very much for this opportunity.
Honorable Jerry Ahmed, is that all? You have to organize his birthday and invite us to attend.
Speaker, I will engage. Speaker, I will engage.
Yes.
Yeah, Mr. Speaker, I just want to make a correction. Honorable Ahmed described Father Campbell as an Irish. But, Mr. Speaker, to the best of my knowledge, Father Campbell is a Ghanaian. He's a Ghanaian. And so we need to correct the records.
So the two of you,
that he's a Ghanaian of Irish origin.
so the two of you must come together and do the needful for us to enjoy with him. We are most grateful for you coming to visit us in Parliament. Yes.
Mr. Speaker, on that auspicious note of wishing a very distinguished person a happy birthday tomorrow, yes, I think let me also join my colleagues to great works he's done for this nation. And we pray for longer life for him. And may Allah take him to the next step. On that note, may we get back to 88-2. Speaker, while I appreciate the fact that when a person completes the law course under subsection 1, it is moot to say that he's eligible to apply to sit the national bar exam. But I appreciate the import of what that clause was trying to envisage. And so I propose we delete it and let it find expression in the regulations. So 88 to be deleted. I so move, Mr. Speaker.
All members, I'll put a question. As many as are in favor, say aye. Those against, say no. All members, the ayes have it. The 88-2 is accordingly deleted. Yes.
Speaker, with respect, if you can grant me leave for us to go back briefly on 74, with your leave, Speaker.
Very well. Let's deal with this amendment before we can do that.
Okay, all right.
Yes. Having looked at 88.1 and then the proposed new clause in XII, Chairman, what is the difference? (88.1) and then the proposed amendment in XII.
But it's a bit of a difference. Speaker, a student enrolled in a professional legal training program before the coming into force of this act shall continue under
The existing regime. That's what.
no under the regime prior to the coming into force of this act. We did
Yes,
some
and
amendments.
then 88.1 is saying that a person who before coming into force of this act is enrolled at the Ghana School of Law and is undertaking the professional law course shall complete the professional law course under the applicable enactment and curriculum in force at the time of enrollment. So I'm asking, what is the difference between these two provisions?
Yeah, Mr. Speaker, I think they carry the same weight.
So which one will you drop?
I think we can drop XII.
So move accordingly for us to.
Mr. Speaker, may I move that amendment proposed under XII be deleted?
Application hereby granted. Now, let's accede to your request to come back to clause
Speaker, thank you very much. 74.
74 under the new,
Yes,
the winnowing document.
the video document. Speaker, qualification for enrollment. Yesterday, a debate ensued here. The Honorable Attorney General even made a point that you may qualify, you may have passed all the exams, but because you may not be a person of high moral character, you may not be enrolled. And Mr. Speaker, I've looked through the qualifications for enrollment, and that is not present. So I propose that we add that to 2D, so that the new rendition will read after C is of a person of high moral character.
74.
Yes. No, I don't have it. I just want us to add to it. Who has objection? Honorable Baba has objection. Okay. That's
Yes, Honorable
Mr. Speaker,
Patrick
you see,
Agwam.
we have the legal profession, the professional etiquette rules. That makes provision for what John
He's
is
talking about,
So I
yes.
don't think we have to legislate on it.
No.
That's my objection.
Yes, you are right. You are right. So let's come to the short title.
Speaker, I think that the LI he's talking about is for lawyers. This is for students who are now becoming lawyers.
You see, John Dako, this law is talking about qualification for enrollment, but not the actual enrollment. Not the actual enrollment. It's talking about qualification for enrollment, but the actual enrollment, the regime is out there.
No, Speaker, I see John's point. To be eligible to be sworn in as a lawyer, to be called to the what we call to the bar. Now, no, at that point, there's been some confusion and it's been abused. Even people have gone to court about it, so we've been struggling to define what does high moral character mean. Because you see, so we cannot legislate on it here, So we have moved away from those mechanisms, John, because it's been abused, and people have suffered unduly.
So let's just go back. Speaker, in a minute. So, AG, are you resolving from your argument we were making yesterday that you can qualify, but because of yes, because you don't have the character required, the standard required, you will not be called. You made the argument, and I agree with you. So you realize that somebody is a thief just before the person is called. And on what basis would you say that this person will not be called? It's only when you can prove that under the law, you must be a person of high moral character before you be called. Otherwise, that person, there will be no legal basis to deny the person the enrollment.
No, Honorable John Dako, this particular law is dealing with your academic qualification to be called to the bar, to be enrolled. But the actual enrollment has conditions for you to satisfy. So if you don't satisfy those conditions, you can qualify per the courses that you have attained, but you will not be called to the bar. So at this particular level, we should not be legislating those conditions based on which you can be called to the bar. That is not what we are called upon to do. Yes, Dr. Sosu.
Thank you very much, Right Honourable Speaker. Mr. Speaker, I think that I tend to agree with the argument of Chief Whip, because otherwise what you'll be doing is that you are going to prescribe moral standards for being called to the bar. Somebody can get up and say that I suspect this woman is a quote and unquote a prostitute, so they cannot be called to the bar. And I think that would be an affront to the law. When you are practicing and you have issues, disciplinary issues, there is a regime that deals with that. So please, for the students, let's allow them. Let them come and train, and let us get them in. Then we can take it from there. Mr. Speaker, thank you so much for the opportunity.
Yes.
My last point, and I won't talk about this again. No, because, Mr. Speaker, the issue of high moral characters is even in our constitution when it comes to the appointment of Supreme Court judge. Yes, that is where we got the Aban case from. Exactly. So it is important. Our constitution requires that before you become a judge, you must be a person of high moral character. And so you have to start that from the time you are called to the bar. We cannot take this out. Before you are called to the bar, you must be a person of high moral character. Otherwise, we're going to end up with a lot of thieves in our court. I rest my case. After that, we can put the question.
Yes, Attorney General.
Right Honourable Speaker, the example I gave yesterday was just to say that the fact that you have passed the law practice course in and of itself is not a basis for saying that you must automatically be enrolled. So there are other criteria that are taken into account. And the Honourable Member for Okwaikwe Central has just pointed out that we have a legal regime for that already in existence. Mr. Speaker, if you remember the case of is it Ama Governor? Ama Ghana. Yeah, Ama Governor. I said I was right. So if you remember the case of Ama Governor, all right, she passed her exams, excellently. But the General Legal Council took a decision not to call her to the bar, not to enroll her onto the role of lawyers, just because of certain social media videos that they saw that they thought were below par in terms of moral turpitude. And so they refused to call her to the bar, and she had to, as the Chief Whip has said, she had to go to court to compel the General Legal Council to call her to the bar. So, Mr. Speaker, I don't think that this is something that we have to legislate here, particularly in light of the fact that if we say of high moral character, as it is stated in Article 94 of the Constitution in relation to us, then you might have to necessarily define what you mean. And I don't think that we can legislate that here.
Yes, Chairman of Committee, the short title.
Mr. Speaker, 66. Mr. Speaker, before the short title, may I just take us back to the winner document on clause 66 1B.
Please move the amendment to the short title, then you can take me back.
Very well, very well. Mr. Speaker, amendment proposed XIII delete reform. Mr. Speaker, reform is very much getting close to reset.
So what will be your new
So we are
rendition?
deleting reform.
What will be the new rendition?
Mr. Speaker, the new rendition will be
The legal education.
it will be Legal Education Act 2026. I so move, Mr. Speaker.
Very well. I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. The proposed amendment to the short title is ordered to stand part of the bill.
Mr. Speaker.
Now,
Mr.
your
Speaker, I
proposal.
thought I said act. It should be bill.
Yes.
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 So may I say it again, Mr. Speaker?
Very well.
Legal Education Bill 2026. I so move.
Very well. So, you said you have concern about some provisions.
Yes, Mr. Speaker. With your indulgence, just taking us back to the WeNote document on 66B. B, it says assign responsibility for invigilating and marking the National Bar examination. May we add scripts to the examination scripts? So, assign responsibility for invigilating and marking the National Bar examination scripts. I so move, Mr. Speaker.
Is the examination in the form of only script? What happened to your advocacy? Is it also a script you are going to mark?
Mr. Speaker, what do we mark? We mark scripts.
Yeah, but if it is online.
Well, it is for the consideration of the House. Yes.
Speaker, Chairman may have to be reminded that in this law, we're making provision for electronic learning, where students may apply AI tools to write their examinations, where that paper scripts may not be available in print for marking. So he may have to avoid getting into that space. In any event, advocacy in that moot assessment, the professor who will be assessing you will be marking you. You will be undertaking an exam, but that exam will not be scripted.
Mr. Speaker, I'm persuaded.
Yes, Majority Leader.
Just to take on board the fact that a script is not necessarily a piece of paper. A script is not necessarily a piece of paper. A script can be on a piece of paper. But electronic online scripts are also there. Electronic online scripts are also there. The platform can be online, the platform can be on a piece of paper. What you have written is the script. What you have written is the script. Pardon? Not necessarily on paper, it can be electronic, it can be on your laptop.
Yes, so,
your script is.
Leader, why do we give problem to ourselves when the problem is not there? The rendition is assign responsibility for invigilating and marking the National Bar examination. So no matter the form of the examination, you are assigned the responsibility of invigilating and marking the exams. That's all. Where from the addition? Long title.
An act to establish the Council for Legal Education and Training to regulate legal education in the country, provide curriculum and standards for legal education, and provide for related matters.
Yes, Chairman of the Committee, any proposed amendment to the long title?
Mr. Speaker, no proposed amendment.
It is for the consideration of the House. In the absence of any proposed amendment to the long title, I'll put a question. As many as are in favor of the long title standing part of the bill, say aye. Those against say no. The ayes have it. The long title is accordingly ordered to stand part of the bill. We have come to the end of a consideration stage of Legal Education Bill 2026. Yes, Majority Leader.
Mr. Speaker, we take the Ghana Investment Promotion Authority bill.
Yes, Minority Leader.
Speaker, just a matter of public interest. Mr. Speaker, I have no objection to the application by the respected leader of the House. But Mr. Speaker, I want to make this inquiry. The Ghana Union of Traders Association has sent a petition. Very well, let me finish. Has sent a petition to the Ministry of Finance on the threshold. I just would want to be sure that the Ministry of Finance, through the Deputy Minister who is here to lead the bill, has actually taken it on board. Mr. Speaker, when we met with them as minority, they expressed serious concerns about their business. And I don't want us to rush this bill as if their petition does not exist. So, Honorable Deputy Minister of Finance, respectfully, the GUTA, Ghana Union of Traders Association, sent a petition expressing a serious concern about the proposed threshold. They brought it. They brought a memorandum. So I just want that to be clear.
Minority Leader, what will happen is that if you have a copy of that particular petition, when we get to the provision in question, you can use the petition to propose an amendment.
Mr. Speaker, thank you for the education. But I just want to be double sure that the government is a listening government. I just want to be double sure.
Mr. Speaker,
Honourable members,
the
Ghana Investment Promotion Authority bill at consideration.
My humble prayer is for us to take motion number 20 and do third reading of the legal reform bill. Then, legal education bill, yes. Humbly,
well.
Mr. Speaker. And my brother Jerry is not opposed at all.
Okay.
Speaker,
Yes,
I've engaged him. He's not
leader.
opposed. When we engaged, the Honorable Minority Leader was not here.
Yes, Minority Leader.
Mr. Speaker, there is a very good reason for enacting our rules to allow for second consideration and to allow for notice to be given when we doing third reading. Mr. Speaker, I am not saying that an issue regarding this bill may suddenly arise, but it may. Mr. Speaker, I don't want our friends in government to create a certain impression out there that everything must be rushed. Mr. Speaker, we just finished consideration. The rule allows us, at least, for us to come back tomorrow and do third reading. Mr. Speaker, there is no need to rush between now and tomorrow. What is it at all that you think will stop you from having the third reading done tomorrow, that at all costs it has to be done today? Mr. Speaker, we should invoke that exceptional provision, Mr. Speaker, only when it is required. Mr. Speaker, now everything they would come for waiver, apply for waiver. Mr. Speaker, our friends in government must really come up with a change. Mr. Speaker, if they mean reset, they should properly reset. Every now and then they will say that, oh, it happened yesterday. It is the reason why you say that under this dispensation there's something new. You have not stopped sole sourcing. Now it is clear, everything sole sourcing. Now today we've just finished consideration.
Honorable Minority Leader.
And you now want to do third reading now.
With
Mr.
all
Speaker,
due respect,
they
you
should
are
come back tomorrow.
operating out of order.
Mr. Speaker, the Minority Leader has a motion that he wants us to take tomorrow. We are trying to clear our calendar, to create space so that the motion can be taken. But if he wants us to crowd tomorrow's agenda, if we crowd tomorrow's agenda and it becomes difficult to take your motion, I don't want you to blame anyone. Don't blame me. I said that, don't blame me. I said don't blame me. We want to clear a lot of issues today. We don't want us tomorrow to come here and be dealing with the legal education bill. So let's just take the third reading. So let us have the abridgment of time so the third reading can be done, so that tomorrow will be free for other equally important motions. I have two motions, Mr. Speaker. I have two motions that are pending. In the order of priority, my motions come before his motion.
Mr. Speaker, the learned Attorney General is in this chamber today. So I'm sure some people want to impress him. Mr. Speaker, but if they want to impress him, they should equally inform him of the industry of members who have ensured that this bill has gone through all the stages. Because, Mr. Speaker, even when he was engaged in other mandates, this House continued to consider his bill. So, Mr. Speaker, that is what they want to do for him. I have made my case that you should not do third reading today. If you want to do it, Mr. Speaker, as it pleases them.
Speaker, I am happy the law students are listening to the Minority Leader.
Motion numbered 19. Attorney General and Minister of Justice.
Right Honorable Speaker, I beg to move that notwithstanding the provision of Order 172, Sub-Order 1 of the Standing Orders, which requires that when a bill has passed through the consideration stage, the third reading thereof shall not be taken until at least one sitting day has elapsed. The motion for the third reading of the Legal Education Bill 2025 may be moved now. I so move.
Honourable members, motion ably moved. Any seconder?
Speaker, I rise to second the motion.
Motion moved and seconded. It is for the consideration of the House. This is a procedural motion. I will therefore put a question. As many as are in favor say aye. Aye. Those against say no. The ayes have it. The motion is adopted. Now, consequential motion numbered 20, Attorney General and Minister for Justice. You have the floor.
Right Honourable Speaker, I beg to move that the Legal Education Reform Bill 2025 be now read the third time. I so move.
Motion ably moved. Any seconder?
Mr. Speaker, I beg to second the motion.
Motion moved and seconded. It is for the consideration of the House. I'll put a question. As many as are in favor of the motion say aye. Aye. Those against say no. Honourable members, the ayes have it. The motion is adopted.
An act to establish the Council for Legal Education and Training to regulate legal education in the country, provide the curriculum and standards for legal education, and provide for related matters.
Members, that the Legal Education Bill 2026 is duly read for the third time and accordingly passed. Yes, Majority Leader.
Mr. Speaker, let me thank colleagues for their industry and the work, the diligent work that they have done to ensure the enactment of this bill. Mr. Speaker, let me also congratulate the Attorney General and Minister for Justice for bringing the bill and successfully shepherding the bill through to the point of enactment. Mr. Speaker, this was a major campaign promise of the National Democratic Congress. And as has been typical of the National Democratic Congress, promises made are delivered. We've made promises and we are delivering on those promises. We promised law students that if they voted for us, we will carry out reforms that will ensure equity, fairness, and access to legal education. We have today successfully passed the bill. We believe that this is the dawn of a new era, where all students will be fairly treated. Whichever law school you go to, whichever law faculty you attend, all of us would end at the doors of the National Bar Examination. All of us. Whether you went to Lagos, or you went to UDS, or you went to UCC, or you went to Winneba, wherever you went to law school, we will all end at the same place, which is the National Bar Examination. And it is there that lawyers will be determined. This is a promise that the NDC made, and we have kept the promise, and we want all to witness that we have kept the promise. Mr. Speaker, let me conclude by once again congratulating the Attorney General and Minister for Justice for bringing the bill expeditiously to this House. But let me thank colleagues also for making time. Sometimes we've sat till very late in the night, and especially our friends on the minority side. Some have really shown commitment to the agenda of the National Democratic Congress. I'm surprised that they campaign on different platforms. They didn't campaign on this platform. But when the bill came, they were so dedicated and committed. And indeed, some of them made very, very far-reaching proposals for amendment, which were carried on the floor. So I want to thank them very much. I hope that in the next electioneering campaign, we'll all campaign on the same platform.
Yes, Minority Leader.
Speaker, with respect, let me add my voice to what the Majority Leader has said in part. Mr. Speaker, indeed, the bill was introduced by the learned Attorney General, and the chair of the committee, together with his ranking and members of the committee, through the industry, shepherded the bill and brought him to the House floor after the referral was made to them. All of us have participated. This is not a bill that identified with a particular party. I concede, indeed, that they made it a campaign promise. I concede. And I'm happy that as leader of the House, he is sharing the success story of his government. What else can a leader say when he has succeeded in making sure a thing like this has happened? Mr. Speaker, however, they equally promised that there will be women banking. Mr. Speaker, that they were going to set up a bank for women. Mr. Speaker, we're done with year 1. Year 2, we have not seen the women bank. 2, Mr. Speaker, they said that when they come into office, they would introduce 24-hour economy, 1 job, 3 shifts. Mr. Speaker, they said that even if you are weeding at night, they will give you torchlight to weed. Mr. Speaker, again, they said that as for soul sourcing, they will never do soul sourcing. Mr. Speaker, the president spoke about soul sourcing at the manifesto lunch when he got into this chamber for the SONA, his first SONA. He talked about no soul sourcing. The second SONA, some few weeks ago, he again said no soul sourcing. The majority leader himself, at the dispatch box, when he was closing the debates on the SONA, re-echoed no soul sourcing. But today, we know that they are the apostles of soul sourcing. Mr. Speaker, they also said that in their government there will be no family and friends. They said there will be no nepotism. Mr. Speaker, they said that contract will be open. Today we know that at the presidency, the deputy chief of staff has been awarded a so-so contract, 11 million by Gold Board. This they said they won't do. Mr. Speaker, so I'm reminding them that the very things they said they won't do, they are doing. Mr. Speaker, they say cocoa, they would increase it to 6,000 per bag. Today they have reduced it to 2,500. So, Mr. Speaker, I am happy that the majority leader is saying that out of 10, they have only 1 success. Mr. Speaker, out of 10, they have only 1 success. Today they have
Honorable Minority Leader, you are asked to correct the record. He didn't say so.
Mr. Speaker, so very well. Mr. Speaker, out of the many promises they made in their manifesto, just one. Today, just one. Mr. Speaker, the value for money bill, Mr. Speaker, that law lacks independence, and the finance minister who introduced the bill could not justify the other jurisdictional, Mr. Speaker, the other jurisdictional interests that they were introducing to help. Mr. Speaker, he said in Canada they had value for money. He said in the UK, but before this house, the finance minister could not bring one law to support, and they have passed a politically exposed law which would not solve the very problem they seek to cure. Mr. Speaker, I will not belabor ab initio. The mighty minority told the people of Ghana that with time they will see the true colors of the NDC. Ghanaians have seen the true colors of the NDC, and I'm sure, just as that poor cocoa farmer said, Mahama, what the in other words, they are saying that the president owes them for their cocoa. He has to pay. No matter what he does, he owes them. Mr. Speaker, I won't belabor. I want to join the majority leader in thanking the members of the committee as well as the backbench. Mr. Speaker, I came here in 2013 and it was difficult to see my way through. I have seen the industry of many backbenchers and it's very impressive. Both sides, Mr. Speaker, you see backbenchers participating in lawmaking, their debate on the floor, the quality of debate. Mr. Speaker, this parliament has a future. So what is important is for the whips, particularly the chief whip on the majority side, to encourage the backbenchers to do more work. Mr. Speaker, the backbenchers are saying, what do you want? Mr. Speaker, I rest my case.
Ghana Investment Promotion Authority Bill 2026 at consideration stage. All members, let's take motion number 21. Minister for Finance.
The minister is unavailable, fortunately, so his deputy is able, willing, and ready to do this.
Yes,
we have to speak.
Minority side.
Mr. Speaker, I rise to move that motion number 21 on today's order paper be taken now. I so move, Mr. Speaker.
Motion move. Any seconder?
Honorable Speaker, I rise to second the motion.
Motion move and seconded. It is for the consideration of the House. This is a procedural motion. The question is, as many as are in favor, say aye. Those against, say no. The ayes have it. The motion is adopted. Now, Ghana Investment Promotion Authority Bill 2025 at consideration stage.
Speaker, for the sake of the records, the chairman of the Winnowing Committee, they convened, considered the referral, and have returned to the House with a report. So what we have is the final product of what they considered for the consideration of the House.
Well,
in pursuance of the referral,
I do not have a copy of that. So you can let me have a copy. Yes.
Speaker,
Are you participating in the bill?
my expectation is that I will be furnished with copies because my backbenchers are complaining that they do not have. It's quite difficult. Sorry, my colleagues are complaining they don't have copies. I do not know if... And don't come and give me 3.
Well, they are just giving us copy of the incorporated one, but we will do the amendment by the original one. Clause 1.
Application of the Act.
Chairman of the committee.
Right Honorable Speaker, no advertise.
It is for the consideration of the House. Any proposed amendment? In the absence of any proposed amendment, the question is as many as are in favor of clause 1 standing part of the bill, say aye. Aye. Those against say no. The ayes have it. Clause 1 is ordered to stand part of the bill. Clause 2.
Establishment of the Ghana Investment Promotion Authority.
Chairman of the committee.
Mr. Speaker, no advertise.
It is for the consideration of the House. Any proposed amendment? In the absence of any proposed amendment, the question is as many as are in favor of clause 2 standing part of the bill, say aye. Aye. Those against say no. The ayes have it. Clause 2 is ordered to stand part of the bill. Clause 3.
Objects of the authority.
Chairman of the committee.
Mr. Chairman, right Honorable Speaker, no advertise amendment.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 3? In the absence of any proposed amendment, I'll put a question. As many as are in favor of clause 3 standing part of the bill, say aye. As many as are in favor of clause 3 standing part of the bill, say aye. Those against say no. The ayes have it. Clause 3 is ordered to stand part of the bill. Clause 4.
Functions of the authority.
Chairman of the committee.
Right Honorable Speaker, clause 4. Amendment proposed. Paragraph B deletes the entire and insert the following for purposes of clarity. And I want it to be captured as contained in page 10.
Honourable members, the proposed amendment by the chairman of the committee is for the consideration of the House. Any further amendment? In the absence of any further amendment, I'll put a question. As many as are in favor of the proposed amendment standing part of the bill, say aye. Aye. Those against say no. The ayes have it. The proposed amendment by the chairman of the committee is ordered to stand part of the bill. Chairman, aye.
Right Honorable Speaker, the same clause 4 amendment proposed, paragraph E, line 3 and 4, deletes the investment climate and advice upon request on the availability, choice and suitability of partners in joint venture projects. And if we delete that, the new rendition will read and we certainly act as a one-stop shop for the promotion and facilitation of investment towards accessibility to information, transparency, and improve ease of doing business. I so move, Honorable Chair.
Honorable Asante Boateng, your proposal is to paragraph E, line 3 and 4, delete the investment climate and advice upon request on the availability, choice, or sustainability of partners in joint venture projects. So after deleting this, what is the new rendition?
After deleting that, the new rendition will be the investment climate and advice upon request on the availability, choice, and suitability of partners in joint ventureship. The new one.
Question?
Right, Honorable Speaker, the new rendition will read, collect, collate, analyze, and disseminate information about investment opportunities and sources of investment capital incentive available to investors, so that we delete the latter part.
Clause 4E as I have here. Clause 4E as I have here is collect, collate, analyze, and disseminate information about investment opportunities and sources of investment capital and incentives available to investors. Are we speaking from the same bill?
Yes, right, Honorable Speaker. I'll take it again.
Yes.
The new rendition will be collect, collate, analyze, and disseminate information about investment opportunities and source of investment capital and incentive available to investors.
That's the new rendition.
Yes.
That's the new rendition.
Yes.
I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Chairman of the committee, aye.
Mr. Speaker, aye. Amendment proposed, paragraph K, line 1. Delete, bring about harmonization in and insert harmonize. So the new rendition will be, harmonize investment policy formulation through collaboration with relevant ministries, departments, and agencies. I so move.
It is for the consideration of the House. Honourable members, any further amendment? In the absence of any further amendment, I'll put a question. As many as are in favor of the proposed amendment standing part of the bill, say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Chairman of the committee, IV.
Honorable Speaker, clause 4, amendment proposed, paragraph M, line 1. After promotion, delete facilitation and regulation and insert and facilitation. So the new rendition will be act as a one-stop shop for the promotion and facilitation of investment towards accessibility to information, transparency, and improved ease of doing business. I so move.
Honourable members, the proposed amendment is for your consideration. In the absence of any further amendment, I'll put a question. As many as are in favor of the proposed amendment say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Chairman V.
Honorable Speaker, amendment proposed. Paragraph P deletes the entire. We are to delete the entire.
Very well. The proposal is to delete the entire P. I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. Paragraph P is accordingly ordered not to stand part of the bill. VI.
The amendment proposed, paragraph Q, line 1, after 4, insert investment promotion in. Investment promotion in.
It is for the consideration of the House. Any further amendment? In the absence of any further amendment, the question is as many as are in favor of proposed amendment say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. VII, Chairman of the Committee.
Honorable Speaker, the amendment proposed, paragraph R, deletes the entire.
Honorable members, any further amendment? In the absence of any further amendment, I'll put a question. Yes. Yes.
Thank you, Mr. Speaker. Mr. Speaker, if you look at the object of the authority, D, it talks about promote and regulate technology transfer agreements in a manner that ensures fair value, strengthens local capacity, and enhance innovation. My emphasis here is strengthens local capacity. But if you look at the functions of the authority, there's no explicit function that deals with local capacity strengthening. I will take some guidance if that suffices, because if you look at the kill, perform any other function that is necessary for the attainment of the objects of this act. But it puts it broader. But if we could have a specific provision in the function that would deal with capacity, because if you look at the existing law, one of the criticism is that it is more attractive to foreign investment rather than even at the detriment of our local capacity and local investment. And so I would wish that we could have a function directly dealing with the strengthening of local capacity.
Yes, Chairman of the Committee.
Right, Honorable Speaker, although the functions are not as exhaustive, that's why we have the queue there to take care of all the other issues that were not brought forth here. So I am of the opinion that the queue takes care of that.
We put a question on the chairman's amendment. As many as are in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Now, Honorable Onyine, what is actually your amendment?
I wanted to catch your attention, and it seems to be a topographical mistake as proposed. The proposed amendment to GI, it was to delete after 4, we insert promotion in, but in the version, it is still promotion 4, for investment promotion 4. So if you still look at the winnowing document that we have adopted for the purposes of this, the mistake still appears there, or a mistake appears there. I will just draw your attention. If we could correct that, because I don't know whether my point is understood.
Yes, we are at the consideration stage.
Yes. So what I'm saying is that at the consideration stage, the chairman moves.
So which one are you talking about? Are you talking about VII?
VII, please. VI.
You are talking about VI.
VI, yes, please.
Now, what is under consideration is VII.
VII.
Yes, it's under consideration.
Yeah,
and
Mr.
Honorable Onyina has raised an issue which we are dealing with.
Yeah,
so if you also bring the VI, how do we reconcile?
So, Mr. Chairman, I was just saying that I'm just drawing your attention that there's a potential mistake.
I get your point, but what normally happens is that if a clause is under consideration, until we exhaust it, you don't move to any other clause. We need to do it one after the other. So that's why I want to hear from Honorable Onyina on the VII.
I agree, Mr. Chairman, but just because we had passed it, I just wanted
we should wait. When we finish this, then you said, oh, Mr. Speaker, I want to take you back to this clause.
Thank you, Mr. Speaker. Mr. Speaker, behind me is Honorable Onyina. We look alike, so I am Advocate Kenneth.
You are Kenneth?
Advocate Kenneth, and this is Honorable Onyina.
Oh, okay.
A lot of people tend to mix us.
Okay, yes.
Maybe I have to go and ask my father.
Very well, very well.
That's on a lighter side. Mr. Speaker, what I propose is that we introduce... Oh, yes. Mr. Speaker, I withdraw that comment. Mr. Speaker, I propose that as part of the functions, they provide or introduce incentives and quotas for hiring local talent and sourcing local materials. If I could take it again, provide or introduce quotas or incentives for hiring local talent and sourcing materials locally.
As a new clause?
Yes, Mr. Speaker.
Yes, it's for the consideration of the House, Chairman of the committee.
Right Honorable Speaker, I'm wondering what the import of that clause will add to the entire bill. I don't think it's necessary.
Yes, what is the import of the
Mr. Speaker, like
amendment?
I did indicate, if you compare, we are making reforms. If you compare this with the other act, one of the major criticisms of local manufacturers, our GRPC Act then promotes more foreign investments and more foreign opportunities, waivers to the negligence of our local investments. And that has been a very huge challenge for GIPC. So we are saying that if you are bringing it into an authority and we want to leave, we want to make it general with a kill, it will not give them that look, it will not solve, or as it were, give them some focus on deliberately creating the local content issues. And that is why I'm making that proposal, because...
So, don't you think the 4A will address your concern? Promote and facilitate investment into and within Ghana that are consistent with the principles of sustainable development, economic efficiency, social inclusion, and environmental responsibility.
Mr. Speaker, I want to let my colleague appreciate that we really see the sense in what he's trying to promote. But when we go forward, he will see that there are other provisions that make room for improvement in local content. For instance, when you get to, I think, Section 31, you see that there is a provision that provides that at least 75% of the employees of the trading enterprise are skilled Ghanaians. So there are provisions in it that cater for it. So we don't need an express provision under the functions of the authority to deal with what he's talking about. Thank you.
So I'll put a question on entire clause 4. As many as are in favor say aye. Those against say no. The ayes have it. Clause 4 is ordered to stand part of the bill. Clause 5. Yes, Chairman of the committee.
Mr. Speaker, Clause 5 amendment proposed.
Honourable Member, Second Deputy Speaker should take the chair. Yes. Chairman of the committee, Clause 5.
Amendment proposed, subclause 1, paragraph D, after authority, insert or a representative of the Commissioner General of the Ghana Revenue Authority, not below the rank of a director. I so move. Oh, sorry. Yeah, right. Let me take VIII first. Amendment proposed, subclause 1, paragraph C, after commission, insert or a representative of the Director General of the National Development Planning Commission, not below the rank of a director. I so move.
Yes. The chairman of the committee has made the proposed amendment or just moving the normal.
There is an amendment.
Amendment, very well. So the amendment is before the House. I'll put, yes,
so,
Deputy
Mr.
Minister.
Speaker, these amendments are just to ensure that in the absence of the Director General of the Commission, at least a representative not below a certain rank is there. The initial one makes it explicit that the Director General of the National Development Planning Commission. So the amendment is that either the Director General or his representative not below the rank of a director. Thank you, sir.
Very well. Honourable members, the question is all those in favor of the proposed amendment say aye. All those against say no. No members, the ayes have it. The proposed amendment is carried. Is it in the same clause?
Yes, Mr. Speaker.
But then what were you doing?
The governor of Bank of Ghana, we are asking for the deputy governor. Then, of course, the NDPC is one of the most critical aspects of this national development agenda. And as such, we should rather then make it the deputy instead of not below the rank of a director, because for the governor, we are saying it should be a deputy governor, not a director. So therefore, if we are saying the deputy governor, then for the NDPC, we should require the deputy, unless the NDPC doesn't have a deputy.
Yes, and Mr. Speaker, the governor has 2 deputies. So we feel that if the governor is not available, we can have at least one of the 2 deputies to be to represent. But when you come to the Director General of the NDPC, we have just allowed that either the Director General or a representative not below the rank of a deputy. I think that not below the rank of a director. I think that a director or above will be able to represent the institution very well.
Very well. So I've already put the question. Yes.
Well, Honourable Speaker, I just wanted to support the Deputy Finance Minister to the extent that with the current rendition, when you want to bring in the Deputy Director, it is already inclusive because the Deputy Director also qualifies to be a director. So the current rendition is something that I think that is already in good taste. Thank you.
Very well. So I'll put the entire clause 5.
Well, Chairman, the X, is there any proposed amendment to IX?
No, because you said we're putting the question on the entire.
No, if you've not done the entire.
The other clauses.
So IX.
Honorable Speaker, IS proposed amendment, subclause 1, paragraph D, after authority, insert or a representative of the Commissioner General of the Ghana Revenue Authority, not below the rank of a director. I so move.
Honorable members, the chairman has moved the proposed amendment to IX. It is before the consideration of the House. I'll put the question. All those in favor of the proposed amendment say aye. All those against say no. Honorable members, the ayes have it. The proposed amendment is carried. Now we turn to X, Chairman of the committee.
Honorable Speaker, S clause 5, amendment proposed, subclause 1, after paragraph D, insert the following new paragraph, as captured on page 12. I so move.
Well, honorable members, the proposed amendment by the chairman is before the consideration of the House. Yes, Chairman of the Constitutional Committee.
Chairman, I think this was a very fatal error in leaving out, considering the role EXIM plays in our export trade and trade generally. So I think this amendment is a step in the right direction to include the Chief Executive Officer.
Very well. Now, Honorable Ampim.
Yeah, Mr. Speaker, rightly so. And it is because the GIPC Act preceded the establishment of the Ghana Exim Bank. And so the original act did not have a representative from Ghana Exim on it. But now, with Exim in place, it makes sense that as we are having a new GIPC, we make provision for them to be represented. Thank you.
Very well. So, honorable members, all those in favor of the proposed amendment to X, say aye. All those against, say no. Honorable members, the ayes have it. The proposed amendment is carried. Let's move to XI. Chairman.
Honorable Speaker, still under clause 5, amendment proposed, subclause 1, paragraph F, opening phrase, line 1 and 2, delete deputy minister and insert director. I so move.
What's the rationale behind of removing deputy minister and inserting the director? Chairman.
The Speaker, it's clear that we don't want executive interference in this whole enterprise. And so we agreed at the committee level that, look, let's do away with the minister. Decision making generally will be from that. And so if you let the minister be in charge or be part of that, I'm sure you want to add some more. Okay.
Mr. Speaker, in fact, this was an amendment. This was an amendment that I proposed.
Oh, okay.
And it's because today we have one deputy minister at the Ministry of Finance. Previously, there were 2 deputy ministers and a minister of state. And so if you limit the representation to a minister or a deputy minister, we may be overwhelmed. There are a lot of boards that the Ministry of Finance needs to have representation. So it is important that we lower it to maybe the level of a director, so that if a minister or deputy minister cannot represent, we can send a director who will be capable to represent the ministry. Thank you, Mr. Speaker.
Thank you very much. Honorable members, I'll put the question. Yes, honorable member for Fishinov.
Thank you, Mr. Speaker. There is a further amendment to the G, where we are saying not below a rank of directors. I want us to add IV. We have the ministry responsible for trade, agribusiness, ministry responsible for finance, ministry responsible for foreign affairs. Mr. Speaker, I want to propose...
Honorable member, I think this is a new...
We'll finish, okay.
So let me put the question first. So I'll put the question on cross 5XI. All those in favor, say aye. All those against, say no. Honorable members, the ayes have it. The proposed amendment is carried. Now, member, let me hear you.
Thank you, Mr. Speaker. We realize that human capital and skills...
So that will be XII.
So I want to add on to G. I think I'm looking like the new... Now, under F, G is the one that has the reps from the ministries. That's page 12. So I want to add to G, you have I have two documents.
G, that is one representative of a private enterprise federation nominated by the private enterprise federation. Is that where you are talking about?
The member is confused. There are two documents. The original one, what you are referring to, is under... No, I'm making a point. There is a winnowed document. So that one, what you are talking about is G. But the original one that we are amending is F. Yes.
So Honorable Freche, whether it's F or G, let's hear your amendment.
All right, thank you, Mr. Speaker. So with the 5F, I want to add an additional one to be IV, the Ministry of Education. The reason why I want the Ministry of Education to have a seat at the GIPC is because it will help us match our targeted investment to have the human capital and the skills that we need. Because now human capital and skills, Mr. Speaker, is now investment assets, which is very critical. And I believe the Ministry of Education should be central in this agency. So in addition to trade, finance and foreign affairs, I propose that we add a new one, the ministry responsible for education. I so propose.
Well, honourable members, that's a new proposed amendment from a member from Offensive North. It's before the House. Leader, let me hear him before I come to you.
Especially, Honourable Speaker, I would want to second my respected colleague, the Honourable Asamoah, in that the Ministry of Education and GIPC has some interaction. And that interaction is based on the fact that the GIPC that deals in ensuring that there's proper investment, or there's proper investment that can come into the country, will have to have some amount of regulation, or if you like, interaction with the Ministry of Education. Because, for example, if some schools are supposed to be established by way of an investment from GIPC's doing, you may want to have the approval of the Ministry of Education for such purposes. So there's a certain kind of interaction that is played by the Ministry of Education and the GIPC. So I would want to support my brother for us to be able to have a representative also from the Ministry of Education.
Well, the proposed amendment has been seconded. It's now before the House. Yes, Leader.
I plead with you to abandon the amendment, because when investors come, a lot of the time, the major challenge is energy. energy is usually a major challenge confronting investors. Electricity. So we may need to have the Ministry of Energy also provided for. And when the investment is in the rural parts, there will be issues of roads. There will be issues of roads. So we need to add Ministry of Roads. And even when the investors fall sick, there will be an issue of health. So the Ministry of Health also should be added. And then they need Attorney General and Minister of Justice to be added to provide legal advice. The point I'm making is that you can't say because there is a relationship. Yes, there is a relationship with almost every sector. But you are looking at an investor coming into the country wanting to invest. What are the agencies or ministries that are particularly central, directly related to the person's activities? So you have foreign affairs, because the person is already a foreigner, he's coming in, there'll be a lot of issues dealing with their embassies and etc. Then there is trade, industry, and agribusiness, because that is where we are hoping to direct them to invest in industries, to invest in agribusiness, and etc. And finance, because we want them to bring in money. But if we expand it on the basis of interaction, we will end up with an unwieldy, council. So I plead with you, let's leave it there. I was at the Ministry of Education as a deputy minister. I understand the interaction between the quality of education and the skill sets that not just investors, the skill sets that industry generally, including those that are foreign investments, will need. But it doesn't warrant that in establishing an authority for this purpose, we should have education representatives. So I plead with you to drop the amendment so that we can.
Very well. So I hope it's been abandoned. Yes, let me hear Honorable Member for Bantuma.
Thank you very much, Mr. Speaker. Mr. Speaker, I very much agree with the Leader of the House on his intervention. However, Mr. Speaker, there's one particular area that is very critical when it comes to investment. It's lands. Even at the risk of, going contrary to what the majority leader said, it's one area that I think we may have to consider. I've had the opportunity to work at the Ghana Investment Promotion Center, GIPC, and I know very well that land issues are very critical. So if it will find favor with members, it's one area that I would like us to consider. Because many investors who come into the country, one of the critical concerns that they have is the problem associated with the land tenure system and how they can navigate through and get land for their investment purposes. As we know, all these investment projects will have to find manifest in space. So it's one area that we may have to consider. Let's just consider having the Ministry of Lands and Natural Resources represented on this on the board. Thank you.
Very well. Yes, Honorable Minister.
Mr. Speaker, listening to our colleagues, they all have very good reasons why more ministries must have representation on this. But as Leader mentioned, not having them serving on the council doesn't mean the council cannot work with them to facilitate investment processes. So I'll plead that they abandon the further amendments and let us limit it to this, because otherwise the council is going to be very big, very large, and it will make them ineffective. But they will still be able to work effectively with the Ministry of Lands and Natural Resources, with Ministry of Education, with the Aegis Department, with everybody. Thank you.
Minister, I think the land matter should not be grossed over it because it's such a critical area. A lot of investment has been coming and their frustration has always been on land matters. So I'm inclined to go with what Honorable Asenso. If not the ministry, or you can find something like the commission can also be represented in a, I think it can do. So let's look at it from that angle. Yes, Chairman of the committee.
Thank you, Honorable Speaker. In the same vein, when you look at the composition, you realize that every location that the investor will select will fall within a district. I am of the opinion that instead of narrowing it down to lands, the land that we're talking about for investment purposes will be within a region, a district, or an area. So why not the local government instead? So if we want to continue on that tangent, we may not move ahead. But if we want to do it or want to add lands, then I would rather advocate for Ministry of Local Government, because for every investment that will come on board will be within a district or a region, and they can take it up from that angle insofar as the land issues are concerned.
Well. So I think we will abandon that proposal.
Mr. Speaker, point of interest. The Interior Minister has just called the majority leader that issues of interior are more important than all this, so we should add the Interior Ministry. But anyway, that's on a lighter note. But to buttress the point that we really appreciate the need for all these the role that all these ministries will have to play in promoting investment. But let's abandon it.
Thank you very much. So I'll put the entire clause.
Mr. Speaker, I would like to make this statement before we move on. Because lands, yes, we need it. Energy, yes, we need it. But if we don't align our investment promotion with our educational strategy, we can bring all investment into the country and they won't survive. And it has happened. We know some companies have folded up within African sub-regions because they did not align the educational systems with their investment promotion. And, countries are going to India and other places to get this, not only curriculum, because our investment must align with our national education strategy and skills. So please, let's consider this very carefully in all these decisions that we are making if we intend not to include education.
Will you abandon it? Well, now that the proposed amendment is abandoned, I'll put the question.
Mr. Speaker, let's put just for the records. Let's put the record once we push that education should be part of it should align with our investment promotion.
So you've not abandoned it?
Speaker, I think he has abandoned it, but he wants it for the record. And that information is well noted. The importance of education in investment. Thank you.
James, what is it?
No, we don't. Mr. Speaker, sorry for taking you back. I was actually...
No, we haven't said yes.
No.
We haven't said yes.
No, please.
We haven't said yes.
Okay, so I'm applying. I'm moving a motion for the matter to be...
Look at it at second consideration. If you've gone past that.
Given that we are here, if Mr. Speaker could hear me.
If it is within clause 5.
Yes, within clause 5. Very important.
Okay, let me hear you.
Mr. Speaker, the object of the bill is to facilitate investment. And as part of that agenda, the grant of quotas for migrant or immigrant quotas as a way of facilitating investment is a key function. Now, you don't want to ask yourself who has the power to grant those quotas. It is the Ministry of the Interior. Mr. Speaker, I want to place on record that when I once served as Deputy Minister, I chaired that committee, the Immigrant Quota Committee. And so if we now have a bill of this nature before us, and we are looking at who and who should serve on the governing board, it is important that the Minister of the Interior, who is clothed with the power to grant immigrant quotas, is made a part of that board. I mean, it would be a terrible omission if we don't include the Minister of the Interior, Mr. Speaker, with the greatest of respect. It's very, very important.
Well. So, Chairman of the committee, that's the new proposed amendment. It is before the House. The minister himself called the leader, and now the chairman of the committee is putting this proposal. Yes, Deputy Minister for Finance.
Chairman, Mr. Speaker, I think that I will beg honorable members to let us make progress, because we have stated there is no way the GIPC will not have working relationship with all the institutions that they have identified. When it requires that GIPC assets some investment persons with matters related to interior, some investors with matters related to interior, they will do so. We don't necessarily need the Minister for the Interior or the Minister for Education or Lands to be a member of the governing board before some of these things can be done. So we appreciate the relationship, and we know that definitely the GIPC will have to work with all these ministries to be able to facilitate investment for potential investors. And so let us not stretch it. What we have seen so far, everybody has cogent reasons why Ministry A or B or C should be represented. But the board cannot be enlarged so much, it will make it so ineffective. So, I mean, all these things coming up shows that we need to stick to the numbers and continue the relationship with them. Thank you.
No, it's only interior.
Mr. Speaker,
okay, let me hear you for the last one.
So, Mr. Speaker, I appreciate the minister's position. But you see, in enacting legislation, we are also mindful of the fact that if there are existing legislations, as much as possible, you try to do some harmonization. Now, the function of granting immigrant quotas, which is performed by the Minister of the Interior, is actually provided for under an Act of Parliament, the Immigration Act 2000. So if we are passing a new legislation, we have to take that into account. It has to be taken into account. And you see, before you grant quotas to immigrants to come into this country and work, I mean, it's a crucial function to ensure that when they enter, they will not pose a threat to our national security. That is why that function is vested in the Minister of the Interior. So we are not overstretching matters. It is very, very important. So I'd urge Honorable Minister to concede on this matter, and let's make quick progress, because it is very important. Mr. Speaker, I ran from the office I was watching on the monitor when this matter came, so I rushed, to the chamber to, put these matters across so that we can
Chairman,
make quick progress.
I'm inclined to go with him. If there's an existing legislation, then obviously we need to factor that. Chairman, I don't know what you say about it.
But Mr. Speaker, this new legislation is not taking that power away from them. The power still resides with the Ministry of the Interior. So saying that because that subsequent legislation has been passed, we need to factor it in here, I don't see how it comes in. Because that legislation is clear and it's still, so it comes back to the point that where there is the need for the GIPC to fall on the Ministry of the Interior to assist investors in this regard, they will do so. We are trying to create the impression that without having a representation on the board, that service cannot be adequately provided for. I mean, that is what I'm finding difficult to understand. I'm not downplaying the role of the Ministry of the Interior in any way, but I'm saying that they don't need to be members of the governing board to be able to do their work as mandated by their enabling act.
Mr. Speaker, you see, Mr. Speaker, the point is that if we go by this argument, then one would say, oh, okay, take out ministry responsible for finance. And when the time comes for us to deal with finance, you simply go there and try to get them to fall in line, and we make quick progress. But, Mr. Speaker, I'm talking about harmonization. When you are passing new laws, you must take into account existing legislation, and if they have not become obsolete, as much as possible, you do some synchronization. That is why I'm saying that given that that particular function, which is very important, which is crucial for investment, I mean, you need to have the Minister of the Interior here, so that right from the outset, if there are issues which have to do with immigrants, getting them to come into our country and work, they will have first-hand information. Because when immigrant quota applications come before the minister deals with them separately. You may say, oh, you can do your work, you go and work in silos and go to the Ministry of the Interior. They will say, oh, no, right from the outset, we didn't know. Administratively, you can be frustrated. But if they are part and parcel of the work from the onset, then we defeat the concept of having agencies of working in silos.
Well. Chairman, let me listen to the Deputy Minister for Tourism. I don't know whether he's also bringing the...
Thank you very much, Mr. Speaker. Mr. Speaker, a quick one. I need this clarification before I propose my amendment. In the governing board, I can see Bank of Ghana, Ghana Revenue Authority, and Ministry of Finance. These three institutions, I'm of the view that if we want to maintain Ministry of Finance, that is it. What is Bank of Ghana's role? What is Ghana Revenue Authority's role? And Mr. Speaker, to add to this, all these people that are coming, most of these investors do come to Ghana at the beginning as tourists. They come and eventually became investors. So, Mr. Speaker, if you are forming a board, and we are those who are driving tourists, who attract tourists to come to Ghana. So if you are forming such a board, Mr. Speaker, it is important, at least, to get the Ministry of Tourism, Culture and Creative Arts in place, or as part of it. So that when we bring those tourists, they will eventually become investors. And that is where this all benefit will come in. So, Mr. Speaker, I beg you, we can't have this board without having Ministry of Tourism, Culture and Creative Arts. And again, Mr. Speaker, we can't have this board with Bank of Ghana, Ghana Revenue Authority, and Ministry of Finance. What would they be doing, all of them on this board? I am of the view that we should just maintain Ministry of Finance, take Ghana Revenue Authority out, take Bank of Ghana out, bring Interior, bring Ghana to a Ministry of Tourism, and then you can have a very formidable board. Respectfully submitted, Mr. Speaker.
You want to take GRA from it? Chairman, let me hear you.
Honorable Speaker, I think we've had a lot of deliberations on these issues, and I want to give in, subject to the minister's comments, that we take on board the Interior Ministry. And with regards to that of tourism and other things, let me explain this. You know, for Bank of Ghana, any investor coming in will be bringing a lot of funds. It could be unlimited. And if they are on the board, it stands that they will understand whatever it is that they want to bring as an investment. And their role is quite different from GRA. GRA are there for purposes of tax. There are two different things. And the Ministry of Finance also will be looking at the investment aspect of it and how it can drive the economy. So we cannot, as it were, compromise on the stance for that of the Bank of Ghana and GRA, and for that matter, Ministry of Finance. But like I said, I would like to give in for that of the Ministry of Interior to be included, so that even as they are coming, they will be comfortable that maybe their immigration issues will be well treated.
So what will be the rendition now? You are adding Ministry.
We'll just add a representative.
Representative of Ministry of Interior.
Lands Commission for investment purposes. Interior. What is it going to do? Interior.
Boss.
Yeah, sorry.
Speaker, I think that there was an original understanding that if care is not taken, every ministry would have to find its name on the Constitution. And that we need to take care of. The Deputy Minister of Tourism gave you a very important suggestion, to the extent that most of this, especially tourists, they end up in this country, first of all, because they came for tourism purposes. But they end up changing. Some even end up marrying. And they end up becoming Ghanaians. But Speaker, what is the Ministry of Finance doing? Ministry of Finance, you have Bank of Ghana, that is virtually connected to Ministry of Finance. You have Ghana Revenue Authority, that is you can't tell me that GRA, Suomoto, can deal with issues of taxes without blessings from Ministry of Finance. And if we are not careful, I would ask that now we should request for Ministry of Defense to be added. And then also request for, because Honorable Parsons also made a very important point about lands, especially when those investors are coming to deal with issues of land. And you want to, as it were, prevent land litigation and ensure. So we can say that then let Ministry of Land also come in. Then let Ministry of Works and Housing come in. Because even the investors who are coming in, where they are going to sleep and stay and everything, we should ensure that Ministry of Works and Housing will take care of their water, they will drink and all of that. So, Speaker, we should be very circumspect, careful, and then rather push for tourism if we have to. Speaker, so in other words, I want to agree with the Deputy Minister of Foreign Affairs more with this suggestion. If not, we should abandon GRA, abandon Bank of Ghana, and only leave Ministry of Finance, because largely they will deal with the monetary policies and issues of providing tax incentives and everything to the institutions or companies that will be coming.
I think the chairman of the committee has explained why these three
agencies, Bank of Ghana, GRA, and Finance Ministry should be in them. But
Mr. Speaker, I looking at the interest in this particular clause, I want to humbly appeal that we put this on ice and make progress. We will consult and come back.
So let's flag this and do further consultation. So I'll hold on putting the entire clause 5. I'll hold on putting the entire clause 5, and let's make progress to clause 6. Yes, clause 6.
Functions of the board.
Chairman, is there any proposed amendment?
Yes, Honorable Speaker. SII Clause 6, amendment proposed. Paragraph D, delete and insert the following as they, and I want it to be captured as contained on page 12. Thank you.
Yes, clause 6D, proposed amendment by the chairman, is before the House for consideration. I'll then put the question. All those in favor of the proposed amendment say aye. All those against say no. Now, members, the ayes have it. The proposed amendment is carried. Clause 6E.
Honorable Speaker, Clause 6, amendment proposed in respect of SIII, paragraph E, line 1, after recommendations, delete directly.
Honourable members, proposed amendment is before the House, and the question is: all those in favor say aye. All those in favor say, all those against say no. Honourable members, the ayes have it. The proposed amendment is carried. So I'll put the entire clause 6. All those in favor that.
Honorable Speaker, there's
SIV.
Yes, a new clause to be introduced there. Clause 6, amendment proposed. Insert the following new paragraph. So that will be given a number. Perform any other functions that are necessary for the achievements of the objectives of the authority. I so move.
Yes. Proposed amendment. All those in favor say aye. All those against say no. Honourable members, the ayes have it. The proposed amendment is carried. Yes, okay.
Thank you, Mr. Speaker. Mr. Speaker, I need some clarification before I make my additional proposed amendment. If you look at D, Mr. Speaker, D says that identify challenges to investment in Ghana and make recommendations to the president. But if you come to the E, it says make recommendations, of course, amendment as amended through the minister. Through the minister. I'm getting clarification for the D because in E, it talks about making the recommendations of areas of investment through the minister. But in D, it talks about the recommendation, but it doesn't go ahead to say whether through the minister or directly, and that has also been deleted. So I want to see clarification whether that should also not D, 6D, whether that also
investment
should be
in Ghana and make recommendations to the president.
Yes.
On steps which may be taken for first.
Whether that should also not be through the minister, or what is that?
Yes, Chairman. Let the Chairman explain.
Right, Honorable Speaker, when you look at the embodiment of the entire bill, we're doing every communication to the president through the minister. So consequentially, anything going to the president should be through the minister.
In this case, is it a minister for trade?
You see, the GIPC is under the Office of Government Machinery. So when you look at the memorandum covering the bill, at any point in time, the president may appoint whatever minister that he so desire to take charge of the authority. But for now, it's a Ministry of Finance that is carrying out that responsibility.
Very well. Yes, Deputy Minister for
Mr. Speaker, the new act provides, we'll have to get the section, that the president designates a minister that will be responsible for investment promotions. And this is because in the past or currently.
So, Mr. Speaker himself is taking the chair, I think it's. So, go on.
So, in the past, because it has been under Office of Government Machinery, no particular minister has taken full responsibility for GIPC. So that is why this act is trying to cure, to say that through the minister to the president, so that we'll have, thank you.
Thank you very much.
Yes, Honourable Member, I'm just informed that you have something to say because you need some direction.
Thank you, Mr. Speaker. Yes, the clarification has been done. So I'm moving forward to make an amendment to the D to read that if insert make recommendations through the minister to the president. That is the D. Make recommendations through the minister to the president.
It's already there. The E is there. D. Or D doesn't have.
And Mr. Speaker, I was explaining that that is important because if you look at the interpretation column, we have defined minister to mean the minister designated in writing by the president to have oversight responsibility over GIPC. And so it is important that communication from GIPC to the president is channeled through the minister. So the insertion of through the minister to the president is correct. So the D will read, identify challenges to investment in Ghana and make recommendations through the minister to the president, instead of make recommendations to the president. Thank you.
Well, this is just to make assurance double sure. If not, boards don't deal directly with the president. The boards and agencies are under the minister. And so all reports and listen from them go through the minister. So they cannot directly deal with the president. That is the practice.
But maybe these days you are meeting challenges. So you want it to be specifically stated that it can only be done through the minister. That meant that in almost all communications, you'll be putting it there, that the board will have to be doing that through the minister to the president. But now when you use the word through the minister, now has the minister any authority to vary that recommendation? Or the minister is just a conduit, which should not be the situation. Because the minister is the one that will be held responsible by the president, not the board. You understand? Because the minister is the one that will appear at the cabinet as an advisor to the president, not the board. And so when you start introducing such phrases, then you are introducing some more complications. Yes.
Thank you, Mr. Speaker. Mr. Speaker, I was making that proposal because of the E. It had a similar rendition, which indicated that they will make recommendations to the president through the minister. So I sought guidance, and the deputy minister explained. And I said that if in that vein, then the D should also have a similar capture. And that is where you came in. So if you read the E, it says make recommendations to the president through the minister on priority areas. Then the D says identify challenges to investment in Ghana and make recommendations to the president without the through the minister. But if you go to the interpretation, it indicates that the minister means the minister designated in writing by the president to have oversight responsibility over the authority under subsection 2 of section 15 of the Act. So it means that, and by the explanation, at any point there could be different sector ministers that the president has designated to have oversight over the authority. And that was my confusion. And they clarified that they want it to be through the minister. And therefore, I went ahead to make that proposed amendment to the deed. Thank you, Mr. Speaker.
Mr. Speaker, we would need your guidance in this, and I just want you to appreciate what led to these amendments. If you look at the current GIPC Act, it says that the center is responsible to the president. And we have challenges where there is no clearly designated minister to be in charge of GIPC, and some confusion where GIPC boss will say, I don't report to you, I report to the president. Even Parliament has had challenges when dealing with GIPC. And so there was this introduction that apart from the authority being responsible to the president shall in writing designate a minister to have oversight responsibility over the authority. And with the introduction of a minister having oversight responsibility over the authority, it then came to the requirement to channel every communication to the president through the minister. These were the discussions at the committee level and the subsequent amendment that the committee made. I will want your guidance. I'm just trying to give you the background to this, for you to appreciate why the need to communicate to the president through the minister. But if you feel that it is implied that communication to the president should be through the minister, and so it doesn't have to be explicitly stated, we'll be guided. Thank you.
The subject matter is investment into the country. Now, when you're dealing with investment into the country, which sector does it fall within?
So, Mr. Speaker, some presidents have placed it under.
I'm not talking about presidents.
So it is flexible in the interpretation column that the minister means the minister designated in writing by the president. So if President A decides that it should be under finance.
Why have you brought this bill? You have brought this bill because the existing law is having some challenges, and you want to improve upon it to make things better, easier for all of us. And so if you see this is one of the areas that there's a challenge, nothing prevents you from amending it. You understand? If investment falls within, let's say, finance or economy or trade, then let's be clear and put it under that sector. That sector will have a minister, and that minister has to be held responsible. That minister will now, through the technical body, the authorities and other agencies, be advised and empowered to also advise the president. But where we are now trying to empower authorities, agencies, and others to be dealing directly with the president, you're going to have challenges with command and control. You know, and order, when we talk about order, which leads to peace, there must be clarity as to remit, responsibility, and your mandate. It's because the laws are not properly sanitized that we're having these challenges. It should be very clear that agencies, authorities will fall under a political leader referred to as minister or secretary of state or whatever. And they are now to deal with the overall boss, the president. When you allow those agencies, then they undermine the authority and power of the ministers. And by the time you realize, I've been noting it these days, where chief executives say that I don't report to you. I was appointed by the president, so I'm dealing with the president, not you. And I mean, there are a lot of things that they lose out, because on a daily basis, the ministers are at cabinet. They are attending international conferences. There are some resolutions, there are some treaties that you know that they don't know. And apart from that, the very delicate issue of politics. Politics is so complex because we are dealing with the polity. And the polity is about the community. And it's from that word polity that you have politics, which is the art and science of managing a community. So it's not for people who might have been very learned and experienced in a technical area to handle all these delicate issues. And that's why you have political leaders called ministers. So if you don't pass them through the ministers and they are dealing directly with the president could be misled. And it has happened a number of times. Yes, please.
We are guided, Mr. Speaker. We were clear that the GIPC, as the President has indicated, should be under the Ministry of Finance.
Yes.
So that is what it is at the committee level that they say, well, it may happen that another government will want it under Ministry of Trade or some. So the definition of minister should be the minister designated by the president to oversee that. But we are clear, and so with your guidance, if we want to be consistent with this. But the issue that the honorable member for Okre raised was an issue of consistency. that under E, it was make recommendations to the president through the minister. But under D, it was identify challenges to investment in Ghana and make recommendations to the president. So we want to know, we want to be consistent and say for D also, it should be through the minister to the president. That is when you came in and I said, we'll yield to your guidance. If you think that through the minister is not relevant, then we have to be consistent. And wherever it says through the minister, we take it out and say to the president. So that is where I said we want your guidance on. Thank you.
Yes, Honorable Member.
Thank you, Right Honorable Speaker. Right Honorable Speaker, I need some clarification from the Deputy Minister before I can propose my amendment. Is there any clause in this amendment stating that GIPC is still going to be under the office of the President? If yes, then we need to take it out entirely and get a dedicated ministry. We don't have a problem if you say finance or trade. We don't have any issue. But as explained by Right Honorable Speaker, yes, if it is finance, finance. If it is trade, trade. But not anything to the office of the President. I'm saying this because I am aware of these discrepancies as a former member of the Finance Committee. Anytime you are calling office of the government machinery, that is when GIPC will be coming. But by then, you'll be expecting them to be working with trade, another time working with finance. So if we want to have a dedicated ministry for them, fine, I don't have a problem, be it finance or trade. But I don't want to see anything, they being under the office of the President. Thank you, Mr. Speaker.
Yes.
Mr. Speaker, I also would urge that a minister is designated as one with responsibility over the GIPC. And preferably, Mr. Speaker, this minister should even be the Minister for Trade. Trade because, Mr. Speaker, in law, trade and investment are Siamese twins. So, Mr. Speaker, whilst in law school, law faculty, and I was the clerk, Mr. Speaker, your clerk was my mate, we studied the law of trade and investment because of the closeness of the two subjects. So they were combined disciplines. So if we're even not too sure about which ministry, we need to bring this particular agency of state under, Mr. Speaker, I would say, without blinking, that the appropriate ministry would be the Ministry of Trade because of the closeness of the disciplines.
You
Mr.
see,
Speaker, I so submit.
Honorable Member, you have to blink. You have to blink. You say you will stay without blinking. You have to blink because the bill you are considering now is sponsored by a minister. And the sponsoring minister is not the Minister for Trade and Tourism or Trade and Investment is the Minister of what? Finance. So you have to blink, which meant that the decision has been taken at the level of the executive. That minister should be responsible for investment. That is why that minister has been given the authority to sponsor this bill, which is before us today. That's why you must blink. It's not the same as
Speaker, I yield. When my father speaks, I must yield.
Yes. So it's very clear that the decision is to place the investment under a sector, and that sector is the Minister of Finance. And so the board will work through the minister to the president. When you start introducing that, you will do that in almost all the clauses. Almost all the clauses. Even when you come to A and you say provide policy guidance and give advice, to ensure the effective and efficient performance of the functions of the authority. Give advice to who? Will you raise that question? Is it to the president? To the president, not the one who has sponsored the bill. It's to the minister. And now, if you are doing that, you'll be inserting unnecessary clauses throughout. It's clear that the authority itself, the authority as the body corporate, not the board. The board is one of the functionaries of the authority. The authority itself is under a sector, under a minister. So all its components are under that sector and that ministry. So whatever they are going to do in recommendations, advice, and everything is to that sector minister. Please, let's get that correct. Presidents have too many things to do. You don't overload them with such things that others could use delegated authority to handle. So please, you rather amend the E, who talks about make recommendations to the president. Yes. It's to the minister, not to the president. Please, that is my guidance. Yes, sir.
Thank you, Mr. Speaker. I'm guided. But it means in that case, both D and E will have to be amended because they all have precedence.
Yes.
Just to add up. Thank you, Mr.
That's
Speaker.
what I just stated.
Thank you, Mr. Speaker.
Chairman, you may do so if you have the decision.
Thank you, Right Honorable Speaker. I'm taking the rendition of D based on the intervention of the Right Honorable Speaker. It will read, identify challenges to investment in Ghana and make recommendations to the minister on steps which may be taken to foster effective linkages between the appropriate institutions and agencies towards addressing challenges to investment. I so move.
Honorable members, the motion to amend clause 6, subclause D has been moved. Any seconder?
Mr. Speaker, I write to second the motion.
Motion moved and seconded is for the consideration of the House. There being no consideration, I put the question. Those in favor of the proposed amendment say aye. Those against say no. Honorable members, the ayes have it. The motion is carried. So what is the next proposed amendment?
Right, Honorable
Have you
Speaker.
finished all on clause 6? Yes, Chairman.
Consequentially, E. It will read, make recommendations to the minister on priority areas of investment, incentives for the promotion of investment.
Honorable members, this is
and the
consequential.
criteria.
You are right, this is consequential, so I'll put the question. Those in favor of this consequential amendment say aye. Those against say no. The ayes have it. Honorable members, the amendment is carried. Honorable members, I'm not going to put the question on the entire clause 6. And the question is that the entire clause 6 as variously amended stands part of the bill. Those in favor say aye. Those against say no. The ayes have it. Honorable members, the entire clause 6 as variously amended is ordered to stand part of the bill. Clause 7.
Duties and liabilities of member of the board.
Clause 8. Nobody has.
Right, Honorable Speaker, Clause 7,
Okay,
amendment
we go back to
proposed.
clause 7, yes.
Amendment proposed, subclause 1, delete and insert the following. So we're taking the whole of subclause 1 and we putting in place the following. As captured on the first paragraph, page 13. I so move. The new rendition will be a member of the board has a fiduciary relationship with the authority and a duty to act with loyalty and in good faith. I so move.
What is the difference? It's the same thing you have repeated. 7.1 as captured in the bill is the same as captured in the order paper.
Yes.
Where is the difference?
Mr. Speaker, respectfully, I think that the document that was shared, there's an original one and there's an old one.
Oh,
So-
okay. What I have here
Yes.
shows that
So the
the
original
same
one doesn't
as
capture what
the
has been-
original one.
Yes, the original one.
My attention was drawn by leaders to something that developed in the House because of the establishment of the winnowing committee. And I think I should clarify this.
Speaker, indeed, when it was laid, it was referred to because of the indications that when the committee returned with the report for the second reading, the report was presented, debated, and adopted. It came with some host of amendments. So the first deputy, who was then in the chair, referred it to the winnowing committee. So the winnowing committee met, and this is the final product from the work that we met and did. And so, but for the sake of guidance, the direction was that as we are considering the final product from the winnowing committee, we'll be doing the comparison with the terms, the original bill as it was brought to the House, so we can follow the changes that have taken place in respect of the work that the winnowing committee did. So I suspect that what may be before you is a copy of the work from the winnowing committee, which has the amendments properly as advertised and then incorporated.
Yes.
Mr. Speaker, to explain further, when your committee met to consider the referral, they made they proposed a number of amendments. The AGs incorporated those amendments and cleaned up, and we brought the report to this House. We proposed that we would withdraw the initial bill and then relay the new one with the amendment that had been incorporated. But we were advised that if we do that, we may have to take it through the entire process again. So the first Deputy Speaker referred the amendments and everything to the winnowing committee that worked on it and have brought the amended bill to the House. So in considering, we thought that it would have been easier for us to take only the amended one and go through. But some advised that we should still use the original one and go through the amendment. So you see that every amendment has already been reflected in the document that the winnowing committee has brought back to the House. So that is it. I still feel that it will be easy for us to go clause by clause with the amended one. That one, the amendments won't be. Thank you.
Honorable members, please, we must try as much as possible not to undermine the authority of Parliament. When a bill is presented to Parliament and referred to a committee, the directive is given by the Speaker to the committee to consider and report to the House, not to any other person. And so no committee has authority to, in considering a referral, refer it at the committee level to the ministry or to anybody to work on. The committee must submit the report back to the House. And the House will now take a decision as to what to do with that report. When the amendments from the committee are voluminous, and you think that it will take more time for the House as a whole to consider those amendments, the House will take a decision and refer to the winnowing committee. Now, after winnowed, the winnowing is to reduce, it's meant to reduce the number of the proposed amendments, to avoid something like repetitions, duplications, and other non-essential proposed amendments. And so you are expecting fewer amendments from the winnowing committee. Then these are now submitted to the table office, and they are captured on the order paper. And so what you still have is your original bill that was laid. And the new amendments are only captured in the order paper. So as you go through the original bill laid, you now take decisions on the new proposed amendments captured on the order paper. But now you have members having the original bill and some members having the winnowed and revised bill. And that is where you'll be having confusion. So that procedure, you have to really look at it. That is what is done at the consideration stage. So I'm surprised that this matter is rising up. Yes.
Mr. Speaker, what you explained is exactly what happened. In fact, the committee did the work, brought the report to the House. The House took a decision. It was the Speaker sitting, the First Deputy Speaker sitting in, who referred all the amendments that the committee has done and everything to the winnowing committee. And when they brought the new version,
why? They have no right to bring any new version.
No, not a new. When they brought it with the amendments.
Who brought what?
The committee's report with the amendments incorporated.
Incorporated into what?
Into the bill.
Yes, they don't have authority to incorporate anything into a bill.
So, Mr. Speaker, that is why the Speaker then said that we should go by the amendments as has been advertised. Because we thought that with the process that you explained, now the amendments in the order paper will not reflect the original amendments that were made. So that it will be easy, so there will be only one document.
Yes, but it's because you've been struggling to explain the incorporated. It's because the winnowing committee incorporated the new amendments into the original bill, and that has now been printed as the bill, which is wrong. Because the House hasn't taken any side decision. When that decision is taken, the old bill that was initially presented will have to be officially withdrawn from the House. And so that one will not be before the House again. And so you have only the new bill that has now to be relayed, which will now be before members for consideration. Yes, Majority Chief Whip.
Speaker, so we are all guided, and I believe that going forward, these guidelines, in fact, I want to propose that, oh, please, so that going forward, Mr. Speaker, these guidelines will be advertised properly, especially and exhibited to our business statement presentations, because it's a guide. When we get to the stage, oh, please, can you please, what is this chorus about withdrawal? The bill is before the House. It is our product. So, I'm not confused. And the chorus we are singing, it has no basis. We are masters of our own rules. And especially our consideration, the rules are relaxed. So the product before us is what we are considering. Speaker, what Speaker has done is like the new practice direction, which will be guided. So what is before us, the direction will be that we consider the bill that has been brought and considered by both the committee, the substantive committee, and the further referral to Winnowing, which has also brought a report. So, Mr. Speaker, we have the original, and the original is also before the House. So we pray that if your direction is that the amendment be effected in respect of the original bill which is before us, then we are guided and we proceed accordingly, so that we take away what is supposedly a product of the Winnowing Committee, and then we deal with the bill, because the amendments, the proposed amendments, are properly advertised in the order paper, and they are before us. This is the stage of consideration. The original bill is here. When an advertised amendment is read out, in respect of the clause in question, the proper decision will be taken by plenary, and then the Speaker will put the question. So the Speaker has only straightened our path. There's nothing erroneous about what has happened. He's straightened our path. So, Speaker, we are guided.
Yes, Minority Leader. Please, Minority Leader.
Speaker, with respect, normally the practice is that when the presiding officer gives direction, which direction is well founded in law and practice, a cue must be taken, and it must be taken in all humility. There is no ego business here. It's not about who wins and who loses. This is legislation. Mr. Speaker, there are 3 documents: incorporated document and non-incorporated document. This house is a house of records. When a document is laid and it is substantially varied, that variation cannot be considered as having formed part of the document before the House. So, Mr. Speaker, I would expect that the respected leader who spoke before me would do the necessary consultation with the sponsor so that the necessary withdrawal is done and the bill relayed. But, Mr. Speaker, this thing about the Winnow document and that they should rather deal with
the original bill that was introduced, and then we should do the advertised amendment. Mr. Speaker, you have 3 documents. So, respected Majority Chief Whip, there is no winner here, there is no loser here. All the winnowing that was done under the able leadership of the leader of the House is meant to enrich the legislation, the bill itself. So, Mr. Speaker, it is very untidy, and we don't want anybody to raise procedural issues. A document that is not before the House cannot become part of the records of the House. So, Mr. Speaker, the majority side should take a cue, withdraw the bill, do the right thing, and come back.
Yes, Minority Leader, well noted. The directive has already been given, and so we don't need to belabor the points. We have a bill that was laid before us. That is the bill that was presented to us. The others are proposed amendments. The bill before us is the one that was laid. And so these proposed amendments are captured in the order paper, and then that's what you use to do the consideration. So we move on. Second Deputy Speaker, please prepare to take the chair. Yes. And so, honorable members, I have the original bill with me here. So we'll be using that as we go along. Yes, so...
Speaker, indeed, it's actually the bill. It's not even original, it's actually the bill. What is around is just a guide. That when you see an advertised amendment, there's a guide as a product of winnowing committee's work. So, Speaker, we thank you.
Well, let's move on. I earlier on called clause 7, and the chair drew to our attention to a proposed amendment. Then we realized that it was the same on the bill that was laid in the House. So we move on. So there is no proposed amendment to clause 7.1. So do I move to clause 8? Yes, I'm told that there are some other amendments to clause 7. Yes, Minority Leader, anything different?
Yeah, Mr. Speaker, just because you indicated that you are withdrawing for First Deputy Speaker to take the chair. Well, for Second Deputy Speaker to take the chair. Mr. Speaker, it's been related to me in respect of our advertised motion to be taken to tomorrow. Mr. Speaker, so I just wanted confirmation of same so that we prepare for tomorrow. Mr. Speaker, that's all I wanted.
Yeah, please. Earlier discussion in conclave agreed that we would take those motions tomorrow. I had some assignment, but I had to come to do this and to assure you that tomorrow to be taken. If possible, 2 motions will be taken tomorrow. In spite of the pressure on you, we'll have to do them, clear these things before we go on recess. Yes, Majority Leader.
Yes, as discussed, tomorrow there are several motions pending. I have at least two motions, and my motions predate his motions. Mr. Speaker, my motion, if you recall, when you admitted my motion predates his motions. So, Mr. Speaker, if you have the energy tomorrow, we will see how many motions you'll be able to take. Depending on your energy level, that will determine how many motions you will be able to take.
Because I know I have two motions. Two motions. And motions that predate the motion of the minority leader. And I think that it is fair to treat all of us fairly, which is to admit motions and take them in the order in which they were admitted. If it turns out that we can't take all of them, then maybe when we resume.
Majority Leader, you can be sure that I'll be very fair. I'll be very fair and firm. But it's not usually the case that motions are taken as they are admitted, in the order as they are admitted. But tomorrow we'll definitely be available to take the motions. And depending on the leadership of the House, we'll go as far as we can tomorrow. What I know is that the decision was that the motion that the minority leader referred to will be taken tomorrow. That was the decision. So we'll do that tomorrow. Yes, Second Deputy Speaker to take the chair. Sorry?
Mr. Speaker,
I heard you. I think I will not allow you to do what you want to do. I want, please. Yesterday, leadership, you were not at the other function. I gave an indication yesterday. I gave an indication to the audience address yesterday that I will be giving opportunity to those who have happy mouths to contribute on the floor. Are we together? Those of you with happy mouths will be getting the opportunity to contribute. Yes. Now, consult. They will define it for you. That mouth includes healthy mouths. And you know, in Parliament, we refer to it as parliamentary language. Those who use parliamentary language. So if you are a fan of using unparliamentary language, you lose the opportunity to be contributing on the floor of the House. Because this is a house of order. Please. The minority leader knows what I'm talking about.
Honourable members, I think I should put the question on clause 7, Roman number 15. And the question is, all those in favor of the proposed amendment say aye. All those against say no. Honourable members, the ayes have it. The proposed amendment to clause 15, that is SV, is carried. Now, SVI, the same clause 7, Chairman of the committee.
Mr. Speaker, clause 7, amendment proposed, subclause 3, line 2, delete 100 and insert 5,000, and in line 3, after done, delete 250 and insert 20,000. Honourable Speaker, this is in respect of the penalties. Just the change.
Penalty, very well. Honourable members, the chairman has made a proposed amendment in clause 7, Roman numerals SVI. All those in favor of the proposed amendment say aye. All those against say no. Honorable members, the ayes have it. The proposed amendment is carried. Now, I'll put the entire clause 7. All those in favor that clause 7, as variously amended, stands part of the bill, say aye. All those against say no. Honorable members, clause 7, as variously amended, is ordered to stand part of the bill. Clause 8.
Tenure of office of members of the board.
Chairman, is there any proposed amendment?
Honorable Speaker, no proposed amendment.
Honorable members, there's no proposed amendment to clause 8. And the question is, all those in favor that clause 8 stands part of the bill, say aye. All those against say no. Honorable members, the ayes have it. Clause 8 is ordered to stand part of the bill. Clause 9.
Meetings of the board.
Yes, Chairman.
Honorable Speaker, clause 9, amendment proposed. Subclause 3, line 2 and 3, delete paragraph J or H of subsection 1 and insert paragraph H and I of subsection 1. I so move.
Thank you very much. Honorable members, the chairman has moved a proposed amendment to clause 9, listed as SVII in today's order paper. All those in favor of the proposed amendment say aye. All those against say no. Honorable members, the ayes have it. The proposed amendment is carried. Chairman, SVIII. Please, whose microphone is on?
Yes. Honorable Speaker, clause 9, amendment proposed, subclause 4, line 1, delete 5 and insert 7 in terms of color.
Very well.
I so moved.
Very well. Honorable members, the proposed amendment is before the House. All those in favor of the proposed amendment, say aye. All those against, say no. Honorable members, the ayes have it. The proposed amendment is carried. And now I'll put the entire clause 9. All those in favor that clause 9, as various amended, stands part of the bill, say aye. All those against, say no. Honorable members, the ayes have it. Clause 9, as variously amended, is ordered to stand part of the bill. Clause 10.
Disclosure of interest.
Chairman, is there any proposed amendment?
Honorable Speaker, no proposed amendment advertised.
The question is, all those in favor that clause 10 stands part of the bill, say aye. All those against, say no. Honorable members, the ayes have it. Clause 10 is ordered to stand part of the bill. Clause 11.
Establishment of committees.
Chairman.
Honorable Speaker, no proposed amendment to clause 11.
Honorable members, there's no proposed amendment to clause 11, and the question is, all those in favor that clause 11 stands part of the bill, say aye. All those against, say no. Honorable members, the ayes have it. Clause 11 is ordered to stand part of the bill. Clause 12.
Establishment of technical committee.
Chairman.
Honorable Speaker, clause 12, amendment proposed, subclause 2, paragraph D, delete and insert the following, as captured on page 13. I so move.
Honorable members, there is a proposed amendment to clause 12, and the proposed amendment is before the House. I'll then put the question, all those in favor that the proposed amendment to clause 12 is adopted, say aye. All those against, say no. Honorable members, the ayes have it. The proposed amendment is carried. Now let me put clause 12 as various amendment. Oh, okay. Very well. Drafters.
So they have.
So clause 12 as various amended. All those in favor say aye. All those against say no. Honorable members, the ayes have it. Clause 12 as various amended is ordered to stand part of the bill. Now, clause 13.
Functions of the technical committee.
Chairman, is there any proposed amendment?
Honorable Speaker, no proposed amendment.
Honorable members, there's no. Yes, honorable member for Efia.
Thank you very much, Mr. Speaker. Mr. Speaker, on the 13A, the technical committee shall advise on the process and procedures. I believe it should be processes and procedures. So I move that we amend the process into processes. Well, let me.
Very well. So, yes, honorable members, I think with this, I'll just direct the drafters to take care of that.
We're drafting in singular.
Yes, member for Chris. Yeah, let me hear you.
Mr. Speaker, thank you. Mr. Speaker, if you look at the clause 13, I think one key issue that businesses also face is disputes, in terms of disputes. And I was thinking that we would want to also make it an explicit provision as a function of the technical committee to also add settling of disputes that may arise.
What do you propose?
I propose that we add additional clause to read provide dispute resolution mechanisms and provide dispute resolution mechanisms for
Very well. Honourable members, I think he is just proposing that we should be clear with our processes of addressing issues.
Yes.
So now you are clear, you want to give us a rendition? Okay, let's hear you.
Mr. Speaker, provide clear, investor-friendly dispute resolution mechanisms.
Let me hear and then I come to you. Yes.
Right, Honourable Speaker, respectfully, if you check clause 11, it demands that the board may establish committees consisting of members of the board or non-members or both to perform a function of the board. And if you read the 2, that is a 2 clause 11, it states that a committee composed of members and non-members shall be chaired by a member of the board. A committee comprised entirely of non-members shall be advisory. So I am indicating that the board itself has the opportunity or has the right to establish committees. So in the event that there is a dispute, the board itself can establish an ad hoc committee to investigate or resolve such matters. It does not need to be given to the technical committee as a function, and that's where I disagree with my brother. Thank you so much.
Thank you very much. So, leader.
Yeah, Mr. Speaker, dispute resolution procedures have been specifically provided for in subsequent clauses. So if you look at clause 44, 44 deals with dispute resolution procedures. So you cannot have a committee advising on how to resolve disputes when there are clear express provisions setting out dispute resolution procedures within the legislation. So kindly abandon that. There's express provision, clause 44. Clause 44.
Yeah, Mr. Speaker, if I may, okay. I made that provision because there are grievance procedures, but it was not, dispute resolution was not part of their functions. We are talking about the technical, but I'm guided, except that because there were grievances procedures, but as a function, it was not mentioned, but I'm guided. Thank you.
Thank you. Leader.
Speaker, not too related to the clause under consideration, but Mr. Speaker, a fundamental issue was raised earlier by me regarding a major stakeholder in this country, a stakeholder that will be greatly affected by this bill. Mr. Speaker, they brought a petition regarding the threshold and some few other matters. Mr. Speaker, I don't want this house to be seen as a house that does not listen. I've just checked with the committee members, including the chair of the committee, as to whether or not they've been able to meet with Gupta to hear them. Mr. Speaker, in the lawmaking process, the theory is that as part of it, we hear the public, we listen to them, and when there's a public memoranda, we have to consider before moving to consideration stage. Mr. Speaker, we are doing this legislation. There is a public memoranda. The committee's first and foremost duty is to at least grant hearing. Mr. Speaker, this side is not obstructing government, but Mr. Speaker, we want the right thing to be done. The minority met with Gupta, and their concern was basically that when they even bring public memoranda to Parliament, we don't listen. I would plead with the respected majority leader to work with the sponsor of the bill. Gupta's memoranda must be heard. We must not rush into doing this bill, and when the matter is raised, you are told that when it gets to that clause, come with your amendment. That's not how it works. Mr. Speaker, just before I sit, you recall that when the VAT amendment bill came into this house, I stood up and I said, I am an entrepreneur and I do trading, and I know how this would affect the ordinary trader on the street. My respected colleague, the Deputy Finance Minister, said, it will change nothing. Go out there. They are being charged 20%. You said you gave your word. Now, Gupta is complaining that you have now set up a technical committee to look into this VAT thing. The very thing that we raise it here, is it because I'm opposing you politically? So even if I'm sharing wisdom, you don't want to listen. You go out there. If you had listened to me, you wouldn't go and set up a technical committee for a possible review during mid-year review. Mr. Speaker, I will conclude by pleading with them. Our colleagues, we know you have your numbers, but at least listen. We are not here to just oppose for opposing sake. There are real issues affecting industry. Listen to Gupta's memoranda. Let's hear them. Let the committee grant fair hearing. Let us look into the threshold issues that they have raised before we come to consideration. It's part of our procedure, my respected colleagues. Don't be dismissive, else it will always come back and haunt this very house. Mr. Speaker, I have made my point and I speak no more.
Thank you very much. Yes, leader.
Mr. Speaker, this bill has been in the works for more than 2 years. Yes, for more than 2 years. This bill ought to have been passed by this House in the 8th Parliament. The proposals contained in this bill were actually crafted when he was a majority leader. When he was majority leader. That was when the original proposals contained in this were crafted. There has been extensive stakeholder meetings and analysis of the proposals, which has led to a virtual rewriting of the bill. Now, what you are talking about thresholds, is something that I have also heard, because they are saying that we are reducing the threshold for entry into the country. It used to be $1 million, and we are reducing it to $500,000 cash. And the reason why the authority or the proposed authority is the sponsor is suggesting that we should change it to $500,000 cash is that the previous legislation said $1 million in goods or in cash. So all that people did was to bring in goods and then claim that the value of the goods constitute 1 million. So the country was not benefiting in terms of actual money being injected into the economy by foreign investors. And so we decided to be more specific that it is cash we are looking for. We're not asking you to bring us goods. We're asking you to bring cash. So now the threshold has been changed so that it is 500,000 United States dollars cash. That is actually more stringent than the previous arrangement, which used to be 1 million goods or cash. These discussions have been had severally. As for the issue of foreign invasion of our economy, it has been a long-standing issue. But it is not because of this bill that we will continue to have that problem. It's a problem that we need to fix in the financial sector of the country, because our traders and manufacturers are borrowing at very high cost. So foreigners who are borrowing at a lower cost can easily dominate your economy. Mr. Speaker, as we speak, we are fixing the financial sector of this country. Interest rates are coming down. It is that which will solve the problem, not this legislation. So I don't want it put out there that we are ignoring GUTA. In any case, I have said what they have said. We can argue it in this chamber, because that is the government of their case, that we are reducing the thresholds. And I've explained why the proponents of the bill are suggesting that the threshold should be reduced, but made more stringent by insisting that it has to be cash, 500,000 United States dollars. If you have arguments against what the proponents are proposing, which you have read from the petition, you can advance those arguments. But I don't like the way you are indicting the chairman of the committee. Mr. Speaker, this chairman did a very diligent work. Chairman has been very, very diligent. He has consulted stakeholders extensively before putting together his report. And the chairman should be encouraged. The chairman should be encouraged. And this is a chairman who's on the MPP side. And you get up and you are trying to belittle the work of the chairman. Mr. Speaker, I will not allow the chairman to be undermined. I
I will not allow the chairman to be undermined. So let us continue. If we get to the investment thresholds and you have specific amendments on behalf of the stakeholders, 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 you can do so, Mr. Speaker.
Thank you very much. So,
Mr. Speaker, I said I speak no more on the substantive issue, but the leader has introduced two matters that I want to address. Mr. Speaker, respectfully, yes, I served as majority leader, but I would want to contest that submission by him that the bill was introduced into this house under my leadership, and that bill sought to amend the threshold. Mr. Speaker, that is incorrect. I beg to submit, just for the records. Two, Mr. Speaker, the issue about Guta has to do with the sponsor. I have not raised any issue regarding the industry of the chair. Mr. Speaker, I would conclude simply by saying that we are gradually making it impossible for consensus building in this house. Where every view is opposed, Mr. Speaker, it is something we must watch. And I am speaking in this house. I speak as an entrepreneur, and I know there are many entrepreneurs in this chamber, on the left and on the right, who trade and know the real issues. So I don't want us to pass a law as if we are detached from the real world. Mr. Speaker, the respected leader says that the economy is doing well. I will not stand anywhere to challenge the numbers, but the numbers must have effect in the lives of the people. The numbers must have effect in the market. The numbers have no effect. Mr. Speaker, it is for him to make his political statement. I will not contest him any longer. Thank you.
Mr. Speaker, wait, for the records. Speaker, for the records, this is the third time he's speaking to this matter on the floor. He has been guided. That petition is not before us. We have long passed the debating the principles of the bill. So if you are minded to carry their views in terms of amendment, you have been guided to do so. But every time you want to speak and damn the government, you are hitting Guta's head against government. As if we are doing something against their interest with this bill. Why?
Yes, Speaker, the minority leader has been making this point, and each time we try to correct him. I don't know why he is so unrepentant. Mr. Speaker, we conducted thorough stakeholder engagement. We have a report, stakeholder engagement report here, showing all the people who attended, including Guta. So what is this? We have done this extensive consultation before coming to the House with this bill. So it is never the case that we did not consult stakeholders before finalizing the bill. We did extensive consultation, and we have a copy of the report of the stakeholder engagement we have been sharing around. If the committee wanted all this information, they were available to be given to them. So we have gone past all these things that the minority leader keeps mentioning.
Leader, I think it's...
For the record, respectfully, just 1 minute. Mr. Speaker, I would want the Chief Whip on the majority side to be guided. When I take issues up and his leader responds to me, unless the leader is not seated and he would want to respond to me. Mr. Speaker, leader has responded to me. His leader has responded. I I do not want issues to be reduced into personal matters. Mr. Speaker, we are not dealing with personality issues here. Mr. Speaker,
thank you, leader.
Mr. Speaker, two. Honorable Minister, Honorable Deputy Minister, with respect, we met, the minority side met with Guta just last week. It was a public function. They stated publicly that you did not engage them and you did not even respond to their petition. Mr. Speaker, don't create the impression that the Deputy Minister of Finance should not create the impression that we just come here and talk because of politics. We are not attacking you. We are raising a fundamental issue coming from a stakeholder. The meeting we had with them was public. So don't say that I keep repeating the same thing because they keep complaining. You are in office. So take responsibility.
Thank you. So, honorable members, clause 13.
Speaker, I entered this house with the respected minority leader. I am not aware that when we get to consideration stage, we allow anybody to bring back issues that we should have dealt with at
the second reading.
A second reading for 30 minutes. Yes, this is a house of democracy. Mr. Speaker, all that he's raised are things that are policy issues. We passed that stage. Yes, it is okay for Guta to meet the minority and make their point. It's true. In fact, even after passing this bill, somebody will not like something about it. But that is law. So, Mr. Speaker,
thank you.
So that we are guided. So that the next time a bill comes, somebody doesn't take us for 30 minutes because he wants to speak his mind. That is not the point of how we call it. In fact, Mr. Speaker, whatever Guta was seeking to amend in this bill, this bill, not that I'm waiting for you. You say you are taking me to Yoko.
Thank you. Minister,
you say you are taking me to Yoko. I'm waiting for you.
Minister, thank you. Minister, thank you.
Is it not Yoko?
Honorable members.
I'm waiting for
Honorable
you.
members, clause 13.
Mr. Speaker, he was busy trying to take me to Yoko. I'm waiting for you at Yoko. You also serve at Road Fund. The report is also there waiting for you.
Minister, thank you. So, honorable members, clause 13. All those in favor that clause 13 stands part of the bill, say aye. All those against, say no. Honorable members, the ayes have it. Clause 13 is ordered to stand part of the bill. Clause 14.
Allowances.
Chairman, any proposed amendment?
Honorable Speaker, no proposed amendment to clause 14.
Honorable members, there is no proposed amendment to clause 14. All those in favor that clause 14 stands part of the bill, say aye. All those against, say no. Honorable members, the ayes have it. Clause 14 is ordered to stand part of the bill. Clause 15.
Executive oversight.
Chairman, is there any proposed amendment?
Yes, Honorable Speaker. Clause 15, amendment proposed. Subclause 2, line 1. After President, delete may and insert shall, so that the rendition will read, the President shall, in writing, designate a minister to have oversight responsibility over the authority. I so move. Honorable Speaker.
Honorable members, the proposed amendment to clause 15. All those in favor of the proposed amendment say aye. All those against say no. Honorable members, the ayes have it. The proposed amendment is carried. So, clause 15 as variously amended. All those in favor say aye.
Mr. Speaker.
Yeah. Oh, okay, sorry. Yes.
Thank you, Mr. Speaker. Mr. Speaker, earlier on, you gave some guidance in terms of, and I want to seek some clarity, in terms of who the authority is responsible to, and indicated that all the issues that comes directly with the president, eventually everybody is responsible towards the president, but for the authority is an agency under the ministry. And I want to seek clarity from the minister or the chairman of the committee if this area, the clause 15, the authority responsible to the president, the I, should not see some amendments. before I make my proposed amendment. This is for clarity and guidance.
Yes, it's important.
John, do you see reason with?
Right, Honorable Speaker, I'm not clear on what the proposed amendments.
I'm saying that the Speaker, when we were looking at the clause 6, in reference to the D and the E, and the Speaker indicated that we should take out the President and maintain through. So I was indicating whether there's, I was just drawing our attention for some clarity and then guidance. Thank you.
Yes, Chairman.
Thank you, Honorable Speaker. If you look at the submission made by the Right Honorable Speaker in line with this, we may have to do some consequential amendment to say that no. Why? To say that the authority is responsible to the president. Right Honorable Speaker, this is an executive function, so I would like to suggest that we leave it as it is.
The minister.
Because it's an executive function, we'll leave it as the president, not to the minister.
Let me support them.
Yes,
Mr. Speaker, I want to support the position of the chairman of the committee. If you go to clause 6, it was referencing either proposals and suggestions going directly to the president. Then we changed it to the minister. So consistently, the 6D and E, we referenced the minister instead of the president because of the way and manner the authorities function, the board's functionality should go to the minister. However, when you come to the executive oversight, already into it is saying that the president may designate a minister. So the president has the power to designate the minister, as can be seen in the clause 6, where the board will be functioning or be reporting through that minister. But in terms of executive oversight, it is consistent that the authority be made responsible to the president.
Thank you very much. Yeah, leader.
I think the practice has always been to locate the Investment Promotion Center, later Council, now Authority. They have always been located in the office of the President. The idea is that when foreign investment is going to happen, it requires the concerted effort of several ministries and ministers and agencies. And because of the President's convening power, his capacity to get all the agencies to act expeditiously, when you locate the Investment Promotion Center in the office of the President, investment gets more speedily processed than if it is just a particular minister. Even though at all times the President will designate a particular minister, and sometimes it's been the trade minister, sometimes it is the minister for finance. But the ultimate authority is the President. And when the investors come into town and they are told that the agency that is going to be processing their investment is actually in the office of the President, they have a certain level of comfort that matters can be expedited because the presidency is involved. So let's leave it the way it is. Trust me, no president has ever directly been, overseeing the agency. He will always designate a minister to oversee the agency.
Mr. Speaker, thank you very much. First is the difficulty of
the amendment we have carried in the light of the issue he has raised. The amendment we carried is not making it mandatory that the president would necessarily have to designate someone. And that takes away part of the executive authority of the president, even though it's seen as a delegated responsibility. We have an executive president, Mr. Speaker, and the president can decide if he thinks that there's a special interest with GPIC. The president should be able to sit and then be taking direct report on GPIC. But by the current amendment, we are saying that the president cannot do that. The president must necessarily appoint a minister to whom shall report to the president. And I think that it was for good reason that the parent law had the may in it, that you give the president an opportunity to either delegate or not to delegate, because all the function, the executive authority is on the president. Now, if you are now tying the hands of the president and say the president must, when it comes to GPIC, delegate, I think that we should be a bit hesitant trying to tie the hands of the president, because we have an executive president. And for good reason, a president can decide one day to say that GPIC has something that I want to champion myself, so they should be reporting to me. So that's the first difficulty. And I was thinking that it is fitting, it is actually going into the heart of his concern. Now that we're saying that the president must delegate, because we have introduced or we have replaced the word may with shall. It therefore means that under what, Mr. Speaker, how is it going to even delegate it? We are saying a minister. Which minister? Is it the Minister of Finance, the minister responsible for trade? Which minister? Because in this act, when you come to the interpretation, minister has not been defined to me Minister of Finance, neither has it been defined to me Minister for Trade.
Very well.
It could be any minister. So, Mr. Speaker, these are the issues that I think that we should be addressing.
Chairman, did you hear? I think that amendment you effected was just to change may to shall. But he is talking about the fact that the feasibility should have been better.
Right Honorable Speaker, I heard him rightly, but with regards to clause 15, I don't think there should be any ambiguity in respect of this. The 15.1, we're talking about executive oversight, and the authority is responsible to the president. I believe we should leave it as is, because when you come to 2, that's the issue my honorable colleague raised. The president may, in writing, designate a minister to have oversight responsibility over the authority. I stand to agree with Honorable Kabiru to the extent that a president, since the office of the government machinery is responsible for GIPC, the president or a president may come and will say, I want to take an oversight over GIPC, and I'm not going to assign any minister to take charge of that. But when that president decides that it should be under his office, what will that president do if we are using the word shall? So I will go with him by going back and using the word may instead of shall. Let's leave the word may there, so that the president's discretionary power can always be exercised. So the 2, my take on it is that it should still read, the president may, in writing, designate a minister to have oversight responsibility over the authority. And the 3 is consequential. The minister, if he designates or appoints someone under subsection 2, may give directives to the board on matters of policy, and the board shall comply. I so move.
Thank you very much. So let me go to a champion first. I'll come to you.
Mr. Speaker, I'm happy the chairman is trying to understand the point you raised. Two things. Every year, those CEOs, they sign performance contracts with the president, not the ministers. And their budget also sits with the president and the OGM. So if I give you the budget and I want to go and report to any other person, no. You come and sign a contract with me, you give me the indication, by the end of the year, I will achieve A, B, C, D. So the mayor that he's proposing, I do agree with him. The president may have interest and deal with them directly, or assign any other minister to deal with any of those institutions. That's why a minister is not defined in the bill, meaning the president can appoint any other minister to handle this institution for us. So I think it is in order. Let's make progress.
I think, okay, I'm going to Obuasi West Koku.
Well, thank you, Mr. Speaker. I do get the point my colleagues have made in respect of leaving it open so that the president may decide how he wants GIPA supervised. But I think we should be guided by history. If you look at those entities who traditionally have been placed under the office of the president, Mr. Speaker, the truth is that they never get supervised. You see, by oversight, I don't think anybody is referring to instructions to do one thing or not to do one thing. You cannot be appointed by the president and then you refuse to do what the president wants. So it is not that kind of political oversight we're looking at here. You're looking at the technical oversight, their day-to-day workings. And in the ministries, the minister has the consultant, he has the technical people, and it is the reason they are in a better position to provide the kind of oversight that we are discussing. I think as a country, we should be moving towards a regime where no entity is placed under the office of the president. Because the architecture of our governance is to have the president who have ministers who advise him and act upon his command, and then these ministers supervise other subnational entities. It should apply to all entities, and I think the discussion ought to be how we move all these entities supposedly under the office of the president, but never getting any supervision really, how we move everything to the various ministries. It is a reason I think on this occasion, let us force the hands of the president to appoint a minister supported by technical people and consultants in the ministry who can provide the kind of technical oversight that we are talking about. I conclude on this point. There's the risk, Mr. Speaker, that you could have a president who says, I want to supervise myself. When we know that that president may not have the technical capacity to supervise. So it's a bit risky to leave it to the discretion of that president. I think if the president wants to exercise any kind of oversight, he should be able to do that through the minister. And I respectfully ask my colleagues that we compel the president to appoint a minister through whom he may supervise the GIPA we're looking to improve. I thank you, Speaker.
Mr. Speaker, just to say that if the president appoints, if the president is mandated to appoint a supervisory minister, it doesn't take away the supervision of the president in overseeing the work at GIPC or GIPA. The reality is that the ministers are supposed to even report to the president anyway. The bottom line here is that when you have a supervisory minister, you can get the effectiveness and efficiency. So really, the president's hands are not tied to say that if he puts and if you go to the office of the president any day, all agencies that are in the office of the president are overseen by ministers. The president will either appoint a special minister of state or what have you and put all of those agencies behind. So I think it is good for this house to break the shall. So the president appoints a minister or designates a minister to oversee the work at GIPA because of the way because at the end of the day, the president really is still responsible for the running of it.
The issue we are confronted is whether to use the shall or may. That's the only issue.
Mr. Speaker, I'll refer our members to Article 195 of the Constitution. Article 195 of the Constitution. And I think that this whole discussion is grounded on Article 195 of the 1992 Constitution. And with my permission, Mr. Speaker, I read. Subject to the provision of this Constitution, the power to appoint person to hold or to act in an office in the public service shall vest in the President. Shall vest in the President. Acting in accordance with the advice of the Governing Council of the service concerned, given in consultation with the Public Service Commission. Mr. Speaker, for all intent and purposes, GPIC is a public institution. We can clearly be qualified as a public service institution. I mean, GPI, Ghana Investment Promotion Council. Okay, it's authority. Mr. Speaker, you cannot, by this particular amendment, take away the powers of the president to have oversight over this institution. In fact, he is the alpha and omega of all these public institutions. So if you are now saying that the president shall, you are saying that the president having the power vested by the Constitution with this power, you are taking it away. And you cannot do that without amending the Constitution. And that's why the use of the word may gives the president the opportunity to delegate his powers. Every minister who comes before this house, except the Attorney General who has been mentioned in the Constitution, is a representative of the president. The president could have decided to come himself here and report on every sector ministry. So, Mr. Speaker, we are dealing with a constitutional issue here, and I think that in all the bills that we have passed, and anyone can take all the bills we have passed, we have never used the word shall. It has always been may. And if we are trying to do this for good reasons why the framers of those particular old statutes of old haven't used the word shall in them. Mr. Speaker, I raise my case.
Thank you. So I think the amendment that has brought all this discussion was to change the may to shall. So from the discussion, the impression I'm getting is that we should maintain the status quo. So the may should maintain. I think the impression I'm getting. Come again.
Mr. Speaker, respectfully, in the bill is shall. So, and we are asking that it should be may.
That is.
Mr. Speaker, the original bill we brought was may.
And the committee wanted to change it to shall.
In writing. At the committee level, in fact, there were a lot of arguments, compelling arguments, and Honorable Kwaku Kwarteng has enumerated a number of them. One that he didn't talk about was that it came out that all those institutions that are found under office of the president don't really have parliamentary oversight. And so the committee felt that we should compel the president to designate a ministry to be responsible for GIPC so that there will be proper parliamentary oversight. And that is what made me yield. You know, I'm also an MP. So I felt that, well, And from the experience with special initiatives and all these things and the mess that they created, we felt that if we will place it under a ministry, so to speak, to have proper parliamentary oversight, it doesn't spoil anything. So, Mr. Speaker, we may yield to carry the amendment to make a shall so that there will be.
Yes, Leader.
Mr. Speaker, the Deputy Minister is from the sponsoring ministry. So if they have been persuaded, then let's treat this like any other bill where we are putting an authority under a particular ministry. So let's rather have amendments that state clearly that the authority is accountable or answerable to the minister. Then we now come to interpretation clause, and then we define the minister as the minister designated by the president. I think that is the consensus that appears to be emerging from the work of the committee and from even the ministry. So let's not go round and say president and then later on.
So it means we are holding on to the amendment. Leader, the impression I got from you, it means that if we are placing all the institution into the ministry, then what Honorable Kwaku said is right. Then it means we should force the hands of the president to get all these institutions under the minister. So then the operative word would be shall.
So we need to change both 15 and then clause 6. So 15, the proposal will be that the authority is responsible to the minister. The authority is responsible to the minister. Then we'll now go to...
Not to the president.
No, to the minister.
Chairman of the committee.
No, the argument is that when you place an authority under the office of the president, very often oversight is lost. That is the argument. And so it is better to place it under a specific ministry. And in this case, the Ministry of Finance and the ministry responsible for finance and the economy. So there will be a change in the budgeting arrangement. The budget will now move from the office of the president to the ministry, which for me gladdens my heart because we have so many agencies sitting at the office of the president that should not be there. Then when you budget for the office of the president and include them, again, you will be attacked for having an over-bloated budget for the office of the president, forgetting that all these agencies are under the office of the president. So the sooner we move agencies to the appropriate ministries, so that we can leave the president and his secretary alone and chief of staff, so that the lean budget that they actually expend will now be revealed, the better for all of us. And so I support the position that we should go back to clause 6 and six what? 6? Yeah.
6E. This is E.
Mr. Speaker, please, clause 6 was amended. The clauses D and E was amended to the minister. So that has been done.
Okay.
And so, Leader, I made the earlier proposal of the amendment of the 15. So if you'll be gracious enough for it to stand in my name so that it can be carried. to change. Yes. So I made an amendment that the 15(1) should say the authority is responsible to the minister, so that the definition for the minister would then reflect Ministry of Finance and Economic Planning. Thank you.
Very well. So I'll put the question on that clause 15(1). So all those in favor of the proposed amendment by the member for Okre, say aye. All those against say no. Honourable members, the ayes have it. The proposed amendment is carried. Now the two. Yes.
So in that case, the 2 will have to be deleted. So I propose that we delete 2, clause 2 of 15. And consequently, clause 2.
Let me listen to.
Because initially, it is because it's under the presidency. That is why the No, it will come. It will take consequential effect. It will take consequential. Initially, because the framers of this bill was saying that it was under the president. If it's no more under the presidency, then the president doesn't have to designate, because we're already indicating in the bill that the minister will refer to Minister of Finance. And therefore, the president does not have to. The agency will be under the Ministry of Finance, which will solve the issue of taking it out of the presidency.
So when you say this, and when there's another president, and the president decides that this particular or this all-important institution is placed in other ministry, let's say Ministry of Trade. So I think
Mr. Speaker, what he's saying is not complicated. The authority is responsible to the minister. Yeah. Now, once you have adopted the position that the authority is responsible to the minister, B then is illogical, where subclause 2 is illogical in the sense that it says the president may, in writing, designate a minister to have oversight responsibility. So that has to go. Yeah. That's what he's proposing, that we delete 2. And then we maintain 3. We maintain 3 subject to some modification. The minister designate under, so instead of the minister designate under subsection 2, we'll just say the minister may give. So make that amendment as well. The minister may give directive to the board on matters of policy, and the board shall comply. Now, Speaker's concern will be addressed when we come to interpretation. And at interpretation, we are faced with 2 choices: to leave it open to the president, or to be more specific about what type of ministry should be responsible for the investment promotion, authority. But that's something that we'll decide when we get to
when we get there, because the law is going to stand the test of time. So if this president decides that I'm placing under this ministry, you wouldn't know the next president where his pressures will be. So I think when it gets to the interpretation, we can work on that.
Mr. Speaker, exactly what you just said. That is why the interpretation makes it open. That minister means the minister designated in writing by the President of the Republic to be responsible for promotion of investment. So today, the President says Minister for Finance. If tomorrow any other president thinks that it should be Minister for Trade, he can so decide. But the Speaker wanted us to be specific. That is why I said, well, today is Ministry of Finance. So if we want to be specific, then we can define minister to mean minister responsible for finance. But if we want to leave the interpretation as we brought it, then this is our opinion, that it should be open so that tomorrow, if President Mama Pat decides that Minister for Tourism should be responsible for investment, then so be it. Thank you, Mr. Speaker.
Yes, Chairman. So now 15.1 has already been amended.
The Honorable Speaker, just a comment. We realize that the entire clause 15 is a policy, it boils down a policy issue, such that GIPC is under the office of the President. So if the policy direction is to be changed, and that's the sentiment of the entire House, then we'll do that. But I think with this, it's a very sensitive issue, taking that responsibility from the President. Maybe he's sitting down there, he doesn't even know what we're doing here. So I'm ready to go with that, but it's a policy direction, and I want to draw the attention of the House to the effect that the Presidency knows that GIPC, and for that matter, this authority bill that we're doing, will be under his supervision. That's the only concern I want to raise.
Very well. So, Honorable Member Fokre, I want you to put the clauses where. Yeah, Kwaku. Hold on, yes.
Yeah, Mr. Speaker, to start with, I don't think it's such a significant change in policy. Throughout the bill, the idea is that the President would appoint some minister to oversight. We're just trying to use the kind of language that would make the supervision more straightforward. I will create the indulgence of my colleague to summarize the provisions like this. So, the authority is responsible to the minister. That is clear. Because we have already defined that minister in interpretation, that it is a minister designated by the President, it is a reason 2 can disappear. But 3 is doing something else and therefore cannot disappear completely. The minister may give directives to the board on matters of policy, and the board shall comply. I think that should be enough. The designated under subsection 2 should disappear. Oh, we've done that for 15. Okay.
That is what I wanted
because I had a deletion of 3.
No.
Okay.
Only 2. But the 3,
okay.
The leader was saying you should be captured well, instead of the minister designated under the subsection 2. Already 2 is gone. So, if you can help us with the rendition.
That is for 2. The first one.
No, the 2 is already gone.
Yeah, 2 is deleted.
So the 3.
The 3 will be the minister may give directives to the board on matters of policy, and the board shall comply. The minister.
Very well. So that is the proposed amendment to 3. All those in favor say aye. All those against say no. Honorable members, the ayes have it. The proposed amendment is carried. But honorable members, let me draw attention before I put the entire clause. Do you see the heading, executive oversight? So will that also be affected?
No, Mr. Speaker. Ministerial oversight is still
it's executive oversight. Okay. Very well. So I'll then put the question. All those in favor that clause 15 as variously amended stands part of the bill, say aye. All those against say no. Honorable members, the ayes have it. Clause 15 as variously amended is ordered to stand part of the bill. Clause 16.
Divisions of the authority.
Honorable Speaker, no proposed amendment.
Honorable members, there's no proposed amendment to clause 16, and the question is all those in favor that clause 16 stands part of the bill, say aye. Please respond well. All those in favor that clause 16 stands part of the bill, say aye. All those against say no. Honorable members, the ayes have it. Clause 16 is ordered to stand part of the bill. Clause 17.
Branch offices of the authority.
Chairman.
Honorable Speaker, Clause 17, amendment proposed. Subclause 1, line 2, after board, delete whether within or outside the country. So the new rendition will read, the board may establish branches of the authority in a place determined by the board for the effective and efficient performance of the function of the authority. I so move.
Yes, honorable members, this is the proposed amendment and it's brought before the House. And the question is, all those in favor of the proposed amendment to clause 17 say aye. All those against say no. Honorable members, the ayes have it. Clause 17 as amended stands part of the bill. And now, and put clause 17 together. So clause 17 as various amended, all those in favor that it stands part of the bill, say aye. All those against say no. Honorable members, the ayes have it. Clause 17 as various amended is ordered to stand part of the bill. Clause 18.
Chief Executive Officer of the authority.
Chairman.
Right, Honorable Speaker, no proposed amendment to clause 18.
Honorable members, there's no proposed amendment to clause 18. The question is, all those in favor that clause 18 stands part of the bill, say aye. All those against say no. Honorable members, the ayes have it. Clause 18 is ordered to stand part of the bill. Clause 19.
Functions of the Chief Executive Officer of the authority.
Honorable members, clause 19, Chairman.
Right, Honorable Speaker, no proposed amendment to clause 19.
Very well. Honorable members, there's no proposed amendment, and the question is, all those in favor that clause 19 stands part of the bill, say aye. All those against say no. Honorable members, the ayes have it. Clause 19 is ordered to stand part of the bill. Clause 20.
Deputy Chief Executive Officer of the authority.
Chairman, is there any proposed amendment?
No, let me finish.
Chairman, I have called you.
Honorable Chair, no proposed amendment advertised on the other paper. But
Very well. Honorable member for Obuasi West, Kolkwati.
Yeah, Mr. Speaker, I want to make an amendment to 21. And it is just to change the shall to may. The President shall, in accordance with Article 195 of the Constitution, appoint a Deputy Chief Executive for the authority. Mr. Speaker, we gain nothing by forcing the hands of the President to appoint a deputy. In fact, if you look at the current law, there's no such requirement on the President. But it has become necessary, as was explained at the committee level, to do that because once the President appoints someone, the Public Services Commission is reluctant to regularize that appointment because they do not find it in the law. That is why 21 has become necessary. But to compel the President is to say, in situations where the President determines that in the name of fiscal prudence, we do not want to have a deputy, as has been for a long time, the President may do so. So my amendment is to change the shall to may. I so move.
Very well. Honorable members, this is the proposed amendment by the member, and I think it's, yes, let me hear Dr. Kabiru.
Mr. Speaker, I think that Honorable Kwaku Kwarteng has come with rather a softer version of what I was trying to propose. So I want to support, because I was actually proposing that we delete the whole of that particular clause. And the reason is that under this, the President has the powers to appoint other people to support, and even the chief executive officer has the power to employ other people to support in the execution. We have a situation where we are trying to be cost effective. And this tendency of legislating deputy directors is actually something that I think this House will have to look at critically. Deputy directors who is supposed to be helping.
Is it deputy chief executives?
Yeah, deputy chief executive director. And this function is basically to help the chief executive director when the chief executive director has special assistant, PAs, and what have you. So I think that would be a compromise version of what I would have proposed. But looking forward, I think that we must run away from creating deputy chief executive officers' positions using the law. Thank you very much, Mr. Speaker. I support the proposed amendment.
Thank you. Yes.
Mr. Speaker, the proposed amendment is not fatal. It still gives opportunity for the president to appoint if he so wishes. But where he determines there is no need for a deputy chief executive, and so I support the amendment.
So, honourable members, the proposed amendment by Honourable Kwaku Kwarteng. All those in favour say aye. All those against say no. Honourable members, the ayes have it. The proposed amendment is carried. And now I'll put the entire clause 19. All those in favour that clause 19 as variously amended. Clause 20, I'm sorry. All those in favour that clause 20 as variously amended stands part of the bill, say aye. All those against say no. Honourable members, the ayes have it. The proposed amendment is carried, and that clause 20 as variously amended is ordered to stand part of the bill. Clause 21.
Functions of the Deputy Chief Executive Officer.
Right, Honourable Speaker, no advertised amendment to clause 21.
Yes. There is no proposed amendment to clause 21. And the question is, all those in favor that clause 21 stands part of the bill, say aye. All those against say no. Honourable members, the ayes have it. Clause 21 is ordered to stand part of the bill. Clause 22.
Secretary to the board.
Chairman.
Right, Honourable Speaker, clause 22, amendment proposed, subclause 2, paragraph B, line 1, delete the Chief Executive Officer so that the rendition will read the B, perform any other function that the board may direct, instead of the board or the chief executive officer. I so move.
Yes, honourable members, that's the proposed amendment to clause 22. All those in favour of that proposed amendment say aye. All those against say no. Honourable members, the ayes have it. The proposed amendment is carried. Yes, Chairman. XXIII.
Honourable Speaker, the same clause 22, amendment proposed, subclause 2, insert the following new paragraph. We added another paragraph to 22 to the extent that, as captured here, we added the arrangement of meetings of the board to the functions of the secretary. So there will be another subclause. I so move.
Honourable members, the proposed amendment to clause 22 again. All those in favour of that proposed amendment? Yes, Honourable Member Fofia.
Mr. Speaker, isn't it inherent in the function of the secretary to the board to arrange for meetings? Should we legislate on arrangement of meetings? If you look at best practice in the laws that we've created,
it is appointment of the board secretary and giving the function or the rule as to where the reporting lines are. But for it to be captured as the secretary should be performed arrange for meetings, I think it is inherited, very irrelevant to be legislated on. That is my view, Speaker.
Yes, leader.
I also think that we might be establishing a very dangerous arrangement, because a recalcitrant secretary will refuse to arrange the meetings even when the board chairman has called for it, where there are divisions and turf wars and etc. So I don't think that it is so critical or crucial to expressly say that the secretary shall arrange meetings. The board chairman, he convenes the meetings. Secretary definitely will serve the notices to members of the board to attend the meeting, and then, engage in the administrative arrangement. Sometimes it is actually the chief executive that assists with arranging meetings, because meetings have to be financed, and secretaries don't have a budget to finance meetings. So secretary is secretary. He should just come and be a secretary at the board meeting and communicate board decisions.
So what's the position of the House now? Yes.
Mr. Speaker, this one I disagree with my leader. The board chair instructs the secretary to convey a meeting. So the secretary will arrange for the meetings. So he's under obligation to arrange for the meetings. He has no any other choice. 22.2. That one is saying the board shall designate an officer of the authority, add the secretary to the board. 2, the secretary shall arrange the business of the meetings of the board. So when instruction is given to the secretary to call for a meeting, he is under obligation to arrange for the meeting.
I agree with Honorable Acheampong on this matter. Mr. Speaker, we look at the function of the board secretary in line with just like a secretary of a company. He has no power to summon meetings, but of course, the arrangement of that meeting, it is his responsibility. The service of notice of meeting, it is his responsibility. And I think that the current rendition reflects that of a secretary of a company. So organizing the business of the meeting is not to convene the meeting. For instance, the agenda, printing of the agenda, and serving of the agenda of the meeting on members is definitely by the secretary to the board. So I think that the current rendition is okay. If we do something about it, we'll be diluting the board secretary's rule. And it's a statutory requirement that the board should have a secretary. And once the secretary is so designated or appointed, this function should follow as of consequence. Thank you very much, Mr. Speaker.
So it means we should
maintain
allowed, we should
let's maintain it and go.
Yes. Honorable Azebuama, are you abandoning your?
Oh, no. Speaker, my position, see, the issue is that we are passing laws, and then we have certain rules. The mic is on. Hello. Yes, and there are certain rules that are not legislated
on. If you look at the company secretary that he referenced, that one is a provision of the Companies Act. And the Companies Act imposes or creates that rule with certain functionality and then obligations and even sanctions. But when we come into these public enterprises that we create, the office of the board secretary is not a major critical functionality. It is only a creation that once you have a board, you create the secretary who facilitates the work of the board under the instruction of the board chairman. So if you are not careful and you begin to introduce, because once you say that the board secretary is to be appointed, you show how the secretary is to be appointed, and then you direct the reporting line. Any other thing that comes to the organization of the meeting sits with the board chairman and even assisted by the CEO. And so it is novel unless we are able to go back. I was trying to revisit our recently passed laws to see how we have created the board secretary rule and whether we have legislated that he would be responsible for arranging of meetings. And I'm saying that arranging the meeting is a necessary role, and that function is given under the instruction of the board chairman. So we don't need to in this particular law impose it that the board secretary is responsible for arranging meetings, since the board chairman calls meetings and it is inherent for the secretary to arrange. Thank you, sir.
Yes. Mr. Speaker, I side with the immediate past board secretary of GRA, Honorable Boama, because you see, what we are in.
He was immediate past secretary.
Yes, board secretary. And he has enormous experience. He has enormous experience as a board secretary, and he's bringing that to bear in the legislation that we are passing. Mr. Speaker, the reason why I support his position is that by introducing this provision that the board secretary shall arrange the business of the meetings, there may be conflict between him and the board chairman when the board chairman wants business A, B, C, D. The board secretary may say, our act mandates me to be the one to arrange the business. I want business E, F, G, H, and not what the board chairman is. We may introduce some unnecessary conflict. So let us leave it as it is. The two functions of the board secretary to keep accurate records of proceedings and decisions of the board, and any other function that the board may assign. If the board decides that he should arrange meetings, so be it, so that this act doesn't give certain powers to. Why are you shaking your head? Thank you, Mr. Speaker.
Mr. Speaker, I was trying to side with the deputy minister, but his concluding part has negated all what he said, that you can assign any other function. If there's conflict, any other function that you assign, he will still not perform it.
So what is the pressure of the House? What is the pressure of the House?
Mr. Speaker, as I speak, I chair a private board. The board is supposed to have a meeting. I've called the secretary and arranged for the meeting.
Honorable members,
so
I think
the inclination from members is that
Honorable Minister, hold on. I think the standard practice of this House, based on the legislations that we've passed, the immediate one, and that's the Ghana Shippers Authority Act, the secretary shall, subject to the directives of the board, arrange the business of the meeting of the board. So that has been the standard practice of the House. And I think we may not need to change the arrangement.
Mr. Speaker, if it is captured in the manner you just read, that's subject to directives of the board, then it's okay. But if you don't and you give that power to the board secretary, it may be the source of the conflict. So we can import the rendition that you just gave.
So the secretary shall, subject to the direction of the board, arrange the business of the meeting of the board. I think that is okay. So with this, I'll put clause 22 as variously amended. So, honorable members, clause 22 as variously amended.
Please, I'm trying to help to guide. Mr. Speaker, someone has to own the amendment before you put it.
Yes, very well. So, Chairman.
So that's the reason
Chairman, may you put the amendment so that...
the amendment proposed to 15
to 22.
22, sorry. I'm sorry. Is that the secretary shall, subject to the directives of the board, arrange for the meetings of the board. I so move.
Let me read this, what I have here again, so that we can... The secretary shall, subject to the directions of the board, arrange the business of the meetings of the board. Yes. So
we're using directions instead of directive.
Well,
and it connotes almost the same.
The same. Very well. So, honorable members, that's the... You don't agree with this?
Mr. Speaker, this House just passed the value for money bill into an act, waiting to be assented to. And there's a rendition here which is departing away from what we are saying right now. Yeah, no, this is GIPC, I agree. And even this, yes, but even this one is further.
So let's hear you, Honorable.
Yeah, this is an authority. Yes, Mr. Speaker, this one is authority, and I believe this one we should even go further and specify the person that qualifies, because the current rendition said the board shall designate a lawyer appointed under, so that section that appoints staff. Then of course, they said the secretary shall arrange the business of the board, record and keep minutes of meetings of the board, perform any other function that the board may direct. Then he goes on, so what Wama was saying, also, the secretary is answerable to the board in performance of the functions of the secretary. So this is a rendition we have just approved as a House, and I believe going with that will not let us depart so much from what we are debating on now. So,
honourable members, that is another rendition.
Right, Honourable Speaker, that version is just an elaboration of the functions of the secretary. We can decide to go by that, and it won't spoil anything. Just an elaboration.
So, Chairman, I mean, just lead us. So if you want that rendition, just let's put the rendition.
Right, Honourable Speaker, to put it in perspective, I think if we go by the elaborated version, we will be covered in all areas. So the board shall, we're not taking the lawyer aspect, because it can be anyone. The secretary shall arrange the business of the board. Then B, record and keep minutes of the meeting of the board. C, perform any other function that the board may direct. Then 3, the secretary is answerable to the board in the performance of the functions of the secretary. We can take that on board.
Honorable, is that okay?
Mr. Speaker, that's okay as long as we are taking out the lawyer from there.
Well.
Otherwise, I will argue that the board secretary should be a teacher.
Well. All those in favor of the proposed amendment say aye. All those against say no. Honorable, the ayes have it. The proposed amendment is carried. And clause 22 as variously amended. All those in favor that clause 22 as variously amended stands part of the bill say aye. All those against say no. Honorable members, the ayes have it. Clause 22 as variously amended is ordered to stand part of the bill. Clause 23.
Appointment of other staff.
Chairman.
Honorable Speaker, no proposed amendment to that.
Honorable members, clause 23, there is no proposed amendment. All in favor that clause 23 stand part of the bill say aye. All those against say no. Honorable members, the ayes have it. Clause 23 is ordered to stand part of the bill. Clause 24, Chairman.
Internal Audit Unit.
Chairman.
Honorable Speaker, no proposed amendment to 23.
Well. Honorable members, there's no proposed amendment. The question is all those in favor that clause 24 stands part of the bill say aye. All those against say no. Honorable members, the ayes have it. Clause 24 is ordered to stand part of the bill. Clause 25, Chairman.
Funds of the authority.
Chairman.
Clause 25, amendment proposed. I'm making a correction to that. It's paragraph C, not E. We should delete that of paragraph C, not E. Yes.
Is that the amendment?
5. We're deleting paragraph C and not E of 25. Yes.
So which one? Can you state which one you want to do?
So we are deleting the entire paragraph C.
C, yes. Income from investment. Yes, as a source of opposed to they are not profit-making entities. Yeah.
Well. Honourable members, the amendment is to delete paragraph C. All those in favor of the proposed amendment say aye. All those against say no. Honourable members, the ayes have it. The proposed amendment is carried. Clause 25 as variously amended. All those in favor that clause 25.
Mr. Speaker, if I may get your leave on the 25, there is no provision for them to take loans. I don't know if it is the intention of government that the authority cannot take loan, because it has been part and parcel of all the legislations we've passed, but it is not here. So if we are minded, we could include, we can do an amendment and insert loans. I thank you, Mr. Speaker.
Chairman and the Minister.
Mr. Speaker, it is not intended for the GIPA to borrow for any major investment. They are to promote investments and not to. But if this House wants to make that provision for the future, I don't think we will be opposed to it. But in the contemplation, it is not for GIPA to be borrowing for anything in particular. We want them to focus on investment promotion and not begin to think of borrowing for any other thing, Mr. Speaker.
Yeah.
Chairman.
Yes, we realize that GIPC, and for that matter, GIPA, is not a profit-making entity. And if we allowing them to take loan, how are they going to pay? Their business is to promote investment. And I think they should focus on that and that alone. So there's no need to legislate for them to be contracting loans on behalf of the authority. Thank you.
Yes, Dr. Kabilu.
Mr. Speaker, just yesterday we had a similar issue. And I remember contributing to SAFE. And in this case, we refer ourselves to Clause 2 of this act or bill. We are establishing a body corporate, Mr. Speaker. And that was the ruling of Mr. Speaker also on that chair, the first Deputy Speaker. We may be putting in place measures to avoid the abuse of that funding source. And I think the ministry has, over the past years, done something about that by capping or saying that before you come for loan, you must come to the ministry for approval. But you cannot set a body corporate and starve it of potential funding sources. If, in the estimation of GIPA, there's the need for them to leverage GIPA to access funds, concessional funds, which can only be accessed by GIPA, I think the country should be able and be willing to access it. But it must take approval of the Ministry of Finance, because you want to avoid contingent liabilities. That's the whole essence of scrapping it, because the whole essence of scrapping is that we are avoiding contingent liabilities on central government, because people are abusing this loan provision in their laws and they can go and contract. But I don't think the solution to that is removing it in the law. I think the solution to that is administrative direction from the President or from the Minister of Finance, stating that no agency shall or would contract loan without approval from the Ministry for Finance. That is the solution. But we cannot be legislating to say that a body corporate should be denied from accessing a particular source of fund. So Mr. Speaker, my submission is that we introduce the loans, because yesterday the Speaker carried that we should include, unless of course I'm wrong. Yesterday, loans was not part, but we introduced loans into the that was value for money office. Value for money office, Mr. Speaker. That one has nothing to do with any activity, just ensuring value for money. But we introduced it back to the bill because we found out that it was necessary to be there. Mr. Speaker, thank you very much.
Well. Yes, leader.
Well, let me correct what you've said, that we cannot be legislating to say that the authority should not take loan. We can. We are a sovereign parliament. If we take a position that they shouldn't take a loan, we can legislate and say that. And in this instance, the sponsor of the bill takes a position that the agency which is presently under them or is likely to be under them should not take a loan. And for good reason, that their functions are such that they don't need to take a loan. They should be sponsored wholly by the state through revenues accruing to them from fees and charges and etc. I think that when we see an agency or an institution that needs to take a loan, we know by the very character of the institution. But for an investment facilitating agency, it is difficult to make a case for them going to take loans. To do what? To pay workers' salary or to build infrastructure. And if they did that, ultimately they'll be passing the loan to the Minister of Finance. So the Minister of Finance should just take the loan and give to them. So right from the onset, they should go and make a case to the Minister of Finance for the Minister of Finance to take a loan and invest in them.
But if you give them the right to do so, they will go ahead and do it. If you say that they can take a loan subject to the approval of the Minister of Finance, then it's the same thing. Then they cannot take a loan. It's the Minister of Finance that is allowing them to take a loan. So they might as well just go to him and ask for the loan. So I think we should maintain the proposal of the committee that we delete income from investments and then we leave it as it is presently rendered.
Thank you. Clause 25, as variously amended. All those in favor say aye. All those against say no. Honourable members, the ayes have it. Clause 25, as variously amended, is ordered to stand part of the bill. Clause 26.
Bank accounts of the authority.
Honourable Speaker, 26, no proposed amendment to that.
Honourable members, there is no proposed amendment to clause 26. All those in favour that clause 26 stands part of the bill say aye. All those against say no. Honourable members, the ayes have it. Clause 26 is ordered to stand part of the bill. Clause 27.
Expenses of the authority.
Chairman.
Honourable Speaker, 27. We have 3 proposed amendments. The first one, amendment proposed, the opening phrase, line 2, after generate, delete sufficient, so that the rendition will read, the authority shall, in the performance of the function of the authority under this act or any other enactment, generate funds to meet the expenditure of the authority, including blah, blah, blah. So we're taking out the word sufficient.
Very well. Yes, Honourable Kabilo.
Yes, we can have further amendment to that. And the further amendment is to delete generate funds to meet the expenditure of the authority. The whole of that phrase should go, so that the new rendition should read, the authority shall, in the performance of this function of the authority under this act or any other enactment, the expenses of the. So, Mr. Speaker, let me come again. I'm proposing that we should delete the whole of generate funds to meet the expenditure of the authority, so that it will read, the authority shall, in the performance of this function, incur the following expenses, and then expenses including A, B, C, D. Mr. Speaker, I say this reference to the previous acts we have passed in this House. The marginal note talks about expenditure. It has not said anything about generating funds. And when it comes to sources of funds, the law has already made provision for sources of funds, including fees and charges. Now, if you are coming to the expenses, you want to talk about expenditure of the board, and you are now imposing a responsibility there again that the authority shall generate funds. In fact, it was sufficient funds, and we are removing the sufficient. I think the previous drafting we have had is so simple. The expenditure of the authority shall include A, B, C, D. Or you can say that the expenses of the authority shall be charged on the funds of the authority. That is how we have been drafting it, Mr. Speaker. And I think that we should go with that angle, because this list here is not even exhaustive. A, B, C, D are not exhaustive of the things that the authority can do. So, Mr. Chairman and Mr. Minister, let's make it simple by saying that the expenses of the authority shall be charged on the funds of the authority, Mr. Speaker, so that it will stay simple as that. Thank you very much, Mr. Speaker.
Very well. Honourable members, that's the further proposed amendment. Yes, Honourable.
But
yeah, Shaibu.
What is wrong with this one? No. Mr. Speaker, I didn't get what the missive.
Mr. Speaker, the chairman for the subsidiary legislation, right, or is asking for the rationale for that, and I refer him to bills that he has actually led in this House on the expenses of authorities. And I'm saying that none of those include this. This, I understand why they should want it to be there. But I'm saying that this list is not even exhaustive. So in the event the expenditure they want to spend on something which is not here, are you going to say it is illegal? So that's why the reason why in the drafting we say that the expenses of the authority shall be charged on the funds of the authority. And you leave it at that. But once you begin to say that they shall generate funds, here you are imposing a responsibility on them which has already been covered under sources of funds. And then you are proposing to say that this is where they should spend the money on again. But for instance, issues about promotion, investment promotion. Mr. Speaker, investment promotion is not stated here. But they can spend on investment promotion. But that is the whole essence of the authority. So that is the point I'm making. Thank you.
Yes, Honorable Shaibu.
Goods and services is talking about administrative. So you can't say it's goods and services. No. Investment promotion is not, sorry.
Speaker, the first leg of his argument is already sorted out. That is why we use the word including. Speaker, the first leg of his argument that the list is not exhaustive is the reason we use the word including. Now the second leg is that it is clear that the so-called funds that they are supposed to have from consolidated fund is not sufficient. And so we're giving the authority the power to generate funds, except if you want to tell us that the authority should not or cannot generate funds. But they can generate funds. And this particular clause is giving them that authority to generate funds. And it goes to state some of the things that it can use. And that's where the including comes in. So, Mr. Speaker, I think this is a good clause, and I will encourage my brother. I appreciate the fact that he's made that comparison about expenses of the authority. But we are going a step further to give them the authority to generate funds. The budgetary allocation has never been enough for most of these things. So those who can generate funds, let's encourage them to do that. And that's why this one should stay. Let me finish with Cap.
Can I come in to just give some...
Is it in line with what?
Yes, I want to give a further explanation to Honorable Kabiru. Mr. Speaker, even though the current rendition for the previous is very short, this is an improvement. And we realize that if you have to invest in investment promotion, it's one of the activities that you can capture under goods and services. If you are doing budgeting, you realize that everything that a public organization will do is either under compensation, which is catered for, is under goods and services, which can be either consultancy, any other services that the organization will provide. Then, of course, you've captured capital expenditure. And also, even allowances, which is also part of compensation, has been captured. So to allay his fear, any other activity that the authority may want to embark on has been captured here, which could be part of their expense.
Well. So, Honorable Kabiru, yes.
Mr. Speaker, the point is made by Dr. Che, so we'll persuade Honorable Kabiru to abandon his proposed amendment so we'll make progress. But by the end of the day, we have goods and services, capital expenditure, and they will generate this revenue for compensation and other expenditures. So please, everything is covered here. So abandon your proposed amendment so that we can make progress. You made a good point, but it doesn't sit well with this provision. Yes.
Honorable members, you know, whilst we are presiding, normally we are also advised by the clerks. So they are making reference to some of the legislations we've already made, and the gold board comes to mind. So is the expense, that's the expenses of the gold board. It's simply the expenses of the gold board shall be charged on the funds of the gold board. And that is probably the angle Dr. Kabiru is going. And that appears to be the standard yes.
No, but Mr. Speaker, we need to situate the whole conversation very well in a proper perspective. Gold boards are a revenue generating institution. Unlike GIPC, which mandate is to promote investment, they are not there to make profit. They are there to promote investment. So if you want to tie GIPC or GIPA to gold board, you may be missing it. They are different entities with different mandates. Though we have other laws that you can quote that you can quote that section or whatever, but they are different institutions with different mandates.
Very well.
Mr. Speaker.
Chairman.
Mr. Speaker. Mr. Speaker, the sponsors of the bill, we don't have a problem taking the rendition that you just quoted. They serve the same purpose. As Honorable Shaibu stated, if we say including A, B, C, D, it cures that possibility that there will be some other expenses. But if we want to go by what you have said, that the expenses shall be charged to the funds of the authority, I think it is neater.
Simple, yes.
It is simpler and it is okay. We can adopt that and solve the problem. Yes, and go. Yes. And my in-law wants to support me, so he doesn't need to speak. He's coming to say the same thing, so sit down.
But once he's here, for him, I'll give him the floor.
You should know that the speaker is my friend, and it's a privilege. Yeah, so I want to support my good brother for consistency's sake. Whether the institutions are the same or not, it's about expenditure, it's about expenses, and it's about spending. So whether they make profit or they don't make profit, we are talking about how they spend the money. And we are saying that in order not to cause any ambiguity, make it very simple and straightforward. And so the expenses be charged on the organization's funds. And so I agree with my good friend, Honorable Kabiru, as well as my in-law, who is also in agreement that we should make the law consistent with what we already have in the system. And so that's my submission. Thank you.
Yes. Now the chairman of the committee, if you
Thank you very much. Right Honorable Speaker, when you look at the imports of 27, the sense that we get from that particular clause is that they must be able to generate funds to take care of all these expenses. But if the focus is on the expenditure that they are supposed to make, it won't be clearer that they're supposed to generate their own funds to take care of compensation, other allowances, goods and services, and capital expenditure. So this makes it so explicit to the extent that they will have to generate funds to foot all these bills. So I don't see anything wrong with this if we leave in the current rendition in the bill to stand as this. It's for clarity and for us to be clear and explicit on the issues that they have to do. They have to generate their own funds to take care of compensation, goods and services, and all allowances. It's explicit and so clear.
Mr. Speaker, did I hear the chairman say they have to generate their own funds to cover compensation and all that? No, that is not it. If you look at their sources of revenue, there is monies approved by Parliament, you understand, and other sources. So it is never the intention that they generate their own funds and use it. No, that is not the case.
Yes. Well, so Honorable Kabiru, give us the rendition.
No, it's not about when you generate expense.
But Mr. Speaker, you see, they are also charging fees. They are going to charge fees, and so they will generate some funds through their activities. But it is never so this to generate sufficient funds to that is wrong. So I would want us to go by the new amendment because we have stated earlier all the sources of funding to them. Thank you.
Okay.
Mr. Speaker, when you say the authority shall, in the performance of the functions of the authority under this act or any other enactment, so take that out and say the authority shall generate sufficient funds to meet the expenditure of the authority. No. Do you get the implication? The implication is that you shall generate funds to meet your expenditure. To deal with your expenditure, you must generate funds. Because it is compulsory, it's mandatory on you to generate funds to deal with your expenditure. That's where my concern is. Is it the intention that the authority should be self-financing? That's how I read it. Should the authority be self-financing? I don't think that's the intention, because the preceding clause makes provision for Parliament. Makes provision for Parliament to make appropriation for the authority. So we can only say the authority may raise funds to meet their expenditure, including the expenditure mentioned in A, B, C, and D. That's my area of concern.
Mr. Speaker, I think the concern raised by the Leader of the House is what we are trying to address with the proposed amendment that I propose. One, it is not within our contemplation that this authority is going to be engaged in investment to generate funds. And that is why in our funding source, we did not include investment income. And that's the point I wanted the chairman to understand, that in our funding source, there was nowhere we included investment fund. So, ab initio, our sources of funding are grants, government allocation, fee and charges. These are our sources of funds for the authority. Now, when you come to the expenditure of the authority, like we have drafted in the past, it is just so simple and make our work easy if we say that the expenditure of the fund shall be, of the authority shall be charged on the funds of the authority. Yeah. And that is how we have cast this particular amendment all of us, so that we avoid every ambiguity whatsoever. And that's the reason why I was proposing that amendment. And I think that the chairman and the committee would be persuaded. If we try to say that expenditure, goods and services is investment income, it is not. Goods and services are expenditure that are accounted for the accounting year, and it doesn't go to the next accounting year. So, Mr. Speaker, let's make it simple, and then the rendition should read, the expenses of the authority shall be charged on the funds of the authority. Simple. Mr. Speaker, I so move.
Very well. So I'll put the question, because it goes with the standard that we've, like I read to the House, that of the Gold Board. And yes, Honorable.
Mr. Speaker, I was supporting that, but Honorable Shaibu drew my attention to something. In this provision, there is generation of funds. We also don't want to lose that entirely, because the authority is also empowered to generate some funds. So we can go by what leader proposed, that the authority may, in the performance of the function of the authority, generate funds to meet the expenditure of, rendition like that, so that the power to generate funds is not completely lost. Yeah, thank you.
We can do that in 23, Mr. Speaker.
Can do that in
23, the sources of funds.
23.
Yes, the sources of the
You've
funds.
already gone past 23.
Yeah, we've gone past that, but we are looking at generation of funds by the authority. If we don't capture that in 23, and then we are anticipating that, we can't address that in the expenditure side. 23 is about sources of funds. Sorry, Mr. Speaker, 24. 22, sorry. 22.
25.
No, it's 25, Mr. Speaker.
25, yes.
It's 25. 25 is about sources of funds. We can address the issue about generating revenue or generating income in 23 so that it will contemplate it as part of the funding sources. So fees and charges is different. Fees and charges are different because we are, unless of course we are saying fees, and then we don't need this amendment. If fees and charges, I agree with you, if fees and charges captures it, then we don't need this amendment. We need to leave it as it is. I thought that they were thinking of where the authority, apart from fees and charges, will be doing other income generating activities in a manner to meet their expenses. If that's not the case, then fees and charges captures it, then we don't need the proposed amendment. Thank you.
So, Chairman, you said you have 3 separate amendments for 27.
Yes, right, Honorable Speaker. The first one, like I said, we were having generate sufficient funds, and we deleted sufficient, and we left the generate funds to read the authority shall in the performance, and from leader is proposing we use May. And,
so Chairman, why don't we take the example that we read out? I think that one is simpler. Then we don't go by all the three separate amendments you want to read. Once we say the expenses of the authority is charged on the authority, I think it covers everything.
Honorable Speaker, can we have that rendition? I don't have that.
So, expenses of the authority. So, yes, leader, can I read and afterwards?
No, Mr. Speaker. You see, the proponents have in mind some interest in encouraging the authority to generate funds. They intend that. And they intend to authorize them, when they generate the funds, to use it even for compensation. Even for compensation. And then to pay other expenses such as allowances for employees, goods and services, and etc. So the Investment Promotion Authority is trying to transition itself into a service provider. And as a service provider, they will be charging for their services. And they will raise revenue. They want to be allowed, when they generate the revenue, to be allowed to keep the revenue, to take care of their expenses. So what Kabiru is proposing is a mere accounting expression. A mere accounting expression that you shall charge your expenses to your funds, your expenditure to your fund. It's a mere accounting expression. But what we have here is a proposal that the authority should be a service provider, generate revenue, and that when they generate the revenue, they may even use it to pay themselves their salaries. That is why I say the only problem is when you say they shall do it, it means that when they don't succeed in doing it, then they don't even have money to pay their salaries.
Yes.
Meanwhile, you've already provided that they can also be given money from the national budget by Parliament. So let us make it, permissive that they may, generate revenue, and if they generate, they can use it to defray these expenses that have been mentioned. That, I think, is the intention of...
so Leader, give us the rendition.
So the rendition is largely the same along the lines of what the chairman is proposing, which is that the authority may, in the performance of its functions under this act or any other enactment, generate funds to meet the expenditure of the authority. I think that's what the chairman is proposing. So that we leave out the compensation, allowances, goods, services, and just say expenditure of the authority. Is that, chairman, is that not what you are proposing?
Well. Yeah, I think that is okay, but like I said, for purposes of clarity, that we put those numbers there. But if the sense of the House is that we should leave the elaborative aspect out of it, we can do that.
Dr. Kabilo, you still want to?
Yeah, Speaker, maybe this will be the last, probably. I don't say never say that as a last, but first and foremost, if you put it in the manner that he puts it, that means that any expenditure or expenditure coming from the authority should be charged on the funds generated by them. That is the understanding. But compensation, you can pay compensation by way of allocation from the budget. It's not generated by them. It's government approval. You can pay for capital expenditure from government allocation. It's not generated by them. It's government allocation. So the difficulty with that rendition is that you are trying to make them live within funds they are generating, which is not possible for the funds. So that is why I'm saying that even if they generate it, it goes into the fund, because sources of fund in our clause 25 includes what they will generate. So even if you are contemplating the sources of fund by way of investment or whatever, it comes to the sources of funds, which will be part of the pool of money they will be charging their expenditure on. So whatever way we look at it, it is part of the fund. Whether they are generating or government is locating it, it's part of the funds of the authority. So I think that on the fund, so I think that the rendition that the expenses of the authority should be charged on the funds of the authority should be what we carry.
Honourable Member, I think you've taken so much time on this. Let me put the question.
Speaker, I think that whilst we are this, the health of members must also be factors. Mr. Speaker, we started around 11, it is 7. No, it's not about putting a question. There's controversy. There are serious matters. Mr. Speaker, the Deputy Finance Minister cannot compel this House by saying that because we are rising tomorrow, Parliament must. Mr. Speaker, there are important motions to be taken. We need to go and prepare. So, Mr. Speaker, if we can end on the next clause and then deal with this thing later. He came here, Mr. Speaker, he came here with the value for money bill, kept the entire Parliament to get it done. Then he brings this one too, without regard to the industry of members, the committee members. Then he comes to sit here that we should stay. It is past 7. Mr. Speaker, we don't have to wait for crisis before we talk about the health of members. I will not support us continuously sitting here because the deputy minister decides to introduce a bill and expect that how this. You've been a backbencher before. You, Honorable Ampil, you've been a backbencher before. You were complaining in those days about your health. when they keep you waiting for a long period. We can't continue sitting. I want you to know. What is this? Majority leader. Majority leader. Health first. You know it. Why? Since morning, we've not even had suspended sitting for members to stretch. Mr. Speaker, can you suspend sitting at least for 30 minutes for members to, yes. Former Chief Whip. My former Chief Whip. The Interior Minister. Teach them. The health of members matter in this house. They should know. We've been sitting since 11, it is 7, then you come, you say we should complete this bill. Members need time to read. You should know this.
Mr. Speaker, the minority leader has suspended sitting more than 10 times today. He, on his own, has suspended sitting more than 10 times. He's walked out more than 10 times. And the way he comes in, he tries to make noise. The speakers have changed 3 times. We started with the first deputy speaker. He changed, and then the second came, and later on the speaker himself came, and now we are back to the second deputy speaker. Some of you have been stepping out and coming back. And Mr. Speaker, clearly, this is a bill in which the industry of members has been recognized. The industry of members have been recognized. Indeed, as a result of that recognition, members pledge to sit here even if it is up to midnight to pass this bill. Oh,
Mr. Speaker, I'm the leader. Excuse me, Mr. Speaker, I am the leader of this side of the House. If the majority leader is talking about his side, he should say so. He should be specific. I don't want him to cause confusion in the front bench here. I am the leader here. And with my deputy here, my whips. We know what, Mr. Speaker, this side, he doesn't appreciate any industry. Maybe to the majority. Mr. Speaker, he was not even at your mother's funeral. He didn't come to your mother's funeral. The deputy minister was not at your mother's funeral. He didn't come. No, we can't do this business. This house cannot continue this business. You should know this by now. You, Ampim, you should know. We will not continue this bill. You should know. It won't happen. You should know. The leader of the house cannot save you. We won't do it.
Leaders. Listen, thank you for the intervention.
Mr. Speaker.
Leaders, thank you for the suspension.
Mr. Speaker, he was not at conclave when we entered into the agreements with which we are working today. I'm sure he needs briefing from his whip. Yes. You need briefing from your whip. So please seek briefing from your whip. Because as for this particular sitting, there is a commitment by all sides to sit till midnight to pass this legislation, this bill. So I think that we can continue.
So thank you. So honourable members, since we are not, when they get to a time, you will suspend. For now, let's move on. Honourable Kabiru, if you are not prepared to abandon it, then you put the question on your, then move on.
Mr. Speaker, I thought they yielded and said we should carry, so it was consensus. So
consensus on your amendment.
We should, yeah, there was a consensus on the amendment. I thought, yeah. So my proposed rendition was the expenses of the authority shall be charged on the funds of the authority.
Yes, but the leader also came out. So I should put that question. So all those in favor of that proposed amendment, say aye. All those against, say no. The noes have it. The noes have it. So what is the next? The chairman's
Mr.
amendment.
Speaker,
Chairman, let's.
Mr. Speaker, we are proposing that we take the chairman's amendment, except that instead of shall, we make it may. That's all. Thank you.
So, Chairman, may you come out with your amendment again?
Thank you, Right Honorable Speaker. The amendment that we're proposing will read as follows. The authority may, in the performance of the functions of the authority under this Act or any other enactment, generate funds to meet the expenditure of the authority, including compensation. Then, in respect of B, we're taking allowances, we're taking the word employees. We're deleting the word employees so that the bill will read allowances of members of the board and committees of the board. So the B will read allowances of members of the board and committees of the board. I so move. Right, Honorable Speaker.
But then ammonia shall be charged.
Honorable members, the proposed amendment by the chairman, all those in favor say aye. I'll put the question again. No, you are here, you don't want to respond. All those in favor of the proposed amendment by the chairman say aye. All those against say no. Honorable members, the ayes have it. The proposed amendment is carried. I will now put the entire clause 27.
Right Honorable Speaker, there are additions to that.
Okay.
And I want to.
let's.
Under the same clause 27, we're introducing a new subclause. As captured, page 14 of the other paper, the last bit of it. And I read, where after having defrayed the outstanding expenses, the authority has an excess amount, the board shall transfer that amount to the consolidated fund unless the Minister for Finance, in consultation with the Minister, approves the retention by the authority of a part or the whole of that excess amount. I so move.
Is carried. Chairman.
Mr. Speaker, I'm the advisor to the chairman on this table. The chairman needs a break. I so move.
So, the drafters, please tidy up this amendment so that we. So, honorable members, the entire clause 27, I'll put it together. All those in favor that clause 27 as variously amended stands part of the bill, say aye. All those against say no. Honorable members, the ayes have it. Clause 27 as variously amended is ordered to stand part of the bill. Leadership.
Let's take a break for 5 minutes. You know I'm not well, so if we can take a break for some 5 minutes, that would do. Yeah.
You have to take his medication. We would, Mr. Speaker, the referral was made to Public Interest Committee, and then the leadership of Budget Committee, myself, Honorable Kwatin, and my deputy, and that of Trade. So all of us attended the meeting. So if the chairman is having a difficulty, I do agree with him. So we can take over, continue. When he comes back, then he takes charge. Mr. Speaker, time is not on our side. Time is not on our side. And his health is also important. So you can go take your medication, allow the committee members to proceed.
Of the bill. 5-10 minutes is enough just to strike up. Please.
Leader, are you to take the suspension?
Yeah, a very short suspension. 5
minutes. Honorable members, I indulge me to suspend the House for 10 minutes.